Title, and Commerce, featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Take notice and acknowledgement with agreement that this show and/or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and/or guidance by a licensed attorney. This private show and/or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
And I'd like to welcome everyone to this Saturday, July 10th, 2010 edition of Money, Banking, and Trust and NTT. Tonight we're going to start on a new corpus juris secundum. We're going to jump to Book 90. Book 90 is the book on trust. And that is 2 volumes. We're going to skip the first sections because it has to do with a lot of material that we've already covered in the past, which is the creation, existence, and the validity of the trust. We're going to jump to Section 3, which is the construction and operation, which starts at Section 160. So on page 9 of the second volume of Trust, starting in Section 160, under the construction and operation of Book 90, Corpus Juris Secundum. So 160, what law governs? A, in general. Ordinarily, in construing a trust, and presently the law of the Creator's domicile controls, and the effect of a trust instrument on realty is determined by the laws of the state in which the property is. With respect to the determination of what law governs the construction of a trust, the question is not meaning of words as used, but rather their legal effect. Ordinarily, in construing and giving effect to an instrument evidencing a trust and personality, the law of the domicile of the Creator at the time of creating the trust must control. And this may be true even though the Creator subsequently removes to the state where the trustees and beneficiary resides and dies there, or although the trustee resides in another state, there being no duty imposed on him to remove the property to his state, or although the trust property be converted under a general authority in the trust instrument and removed to another state. However, it has been held where a trust instrument is executed in one state by residents thereof, and the other state is the seat of the trust, the law of the latter state should be applied in determining whether the trust is irrevocable. And the construction of the trust instrument executed by a non-resident and the management of the trust thereby created in personality having a situs in a particular state must be determined by the laws of that state. Whether or not there shall be an application of the income to a judgment creditor of the beneficiary must be determined by laws of the state in which the application to reach the fund is made. The effect of the trust instrument on real property must be determined by the laws of the state in which the property is located. But the mere fact that the trust property has been actually sited in a particular state and consists in part of real estate does not require that the laws of that state should govern the construction of the trust where the domicile of the settler is elsewhere. And it has been held that where a declaration of trust relating to real property is made in a state by citizens thereof, and it does not appear that the obligations thereof are to be performed elsewhere, the law of that state must control as to its interpretation. The construction of a trust evidenced by contract is to be governed by the law of the place where such contract has its beneficial operation, or where it was executed. In the case of a trust established by a court, having control of the fund requiring a trustee to administer it, in the absence of express provisions expressly governing the matter, the law of the state in which the appointing court is located should control the powers of the trustee and the construction of the instrument. The equitable interest of a city key is governed by the same rules of law as is the corresponding legal estate. Particular circumstances combining various elements and factors in which the law governing the construction or interpretation of trusts have been determined are set out in the note. Removal of trustee to other state. After a trust has been set up in one state, the mere removal of the trustee to another, even though that he takes the trust assets with him, will not alter the original location of the trust or the law governing its interpretation and administration. Next, assignment of interest. The law of the state in which the trust was established determines the interest trusts are assignable. Next, in law in force at the time, trust instruments are executed and delivered, governs their construction. Next section, situs of trust. Situs of a trust, meaning a place of performance of the trustee's active duties, is determined from various factors, particularly the donor's intent and the place of administration. The situs of a trust means the place of a performance of the active duties of the trustee, and such situs is determined by the interpretation of the words by which the trust is created, but other factors have also been considered. Where the settler selects as a trustee a bank or trust company of a particular state, the situs of the trust has been held to be in that state or at the principal office of the bank or trust company. If the case cannot, thus various circumstances may be considered, such as domicile of the settler, the situs of the trust res, or other similar circumstances. So it has been held that in determining the situs or seat of a trust, the place of execution of the trust instrument and the domicile of the beneficiaries are not important indicia, that the domicile of the trustee and the place of administration of the trust are important factors, and that the intent of the donor, if it can be ascertained, has been increasingly emphasized. B. Administration of trust. While ordinarily a trust is administered in accordance with the law of its situs, has been accorded to the domicile of the parties, the place of the executing the trust instrument, its language, the settler's intention, and other factors. Probably the place where the trust inter vivos is to be located and administered is determined by the intention of the settler. In determining that what law governs the administration of an inter vivos trust, it would seem necessary to consider how the creation of the trust was brought about, the domicile of the settler and that of the trustee, whether the trustee is an individual or a corporation, whether the property is real or personal, and the intended site of the property, if it is personality. So in deciding what law shall govern the administration of the inter vivos trust of personality, varying weight has been accorded such elements as the domicile of the settler, of the beneficiary, and of the trustee, the place where the trust instrument was executed, the language of the instrument, the location of the trust property, the place the business of the trust is carried on, and the intention of the authorities are not in complete accord, and some courts give dominance to one element or a combination of elements and some to other. But it seems to be generally recognized rule that where the predominant number of elements are grouped in one state, the group prevails over any single element, and especially so where the intention of the settler is included in a larger group. The location of the administration of the trust means a place of the performance of the active duties of the trustee. Ordinarily, a trust is administered in accordance with the law of the situs or seat of the trust, and a trust will be administered under the laws of the state in which the corpus of the trust is located. So the administration of the trust of land is governed by the law of the state where the land is, and can be supervised by the courts of that state only. Domicile of the trustee and the place of administration of the trust have been held to be quite generally the same place. If the creator of the trust appoints a trustee, a trust company, or another state, presumably his intention is that the trust shall be administered in the latter state under the laws thereof, and the trust will therefore be administered according to the law of the latter state. The administration of the trust of movables is supervised by the court of that state only in which the administration of the trust is located. Where the domicile of the settlor is in one state and the size and place of the administration is in another, the domicile of the settlor is not the absolute and controlling consideration in determining the law which controls the administration of the inter vivos trust in intangible personal property. Where the domicile of the owner of the res of the trust, inter vivos, and the actual and business situs of the trust do not coincide, the law applicable to the interpretation and construction of the trust and the legal obligations arising out of it depends on the facts involved in and the circumstances surrounding the particular case. So, where the actual business situs of the trust, the intent of the settlor has this domiciliary law shall not be applied to the test to administration, and the domicile of the trustee's coincide, and the law of the place of location and administration of the trust controls, regardless of the place of execution of the trust instrument. A state statute on the appointment of qualification of trustees and supervision of administrations have been held to apply only to trusts requiring or involving administration in that state. Next section, subsection, legality of administrative action. In most cases, the legality of administrative action taken under a trust is determined by the validity or invalidity of the trust in the state in which it was originally created and intended to be administered. But that rule should not apply when the act claimed to be invalid was done after the location of the trust and the assets have been legally moved to another jurisdiction pursuant to the provisions of the trust deed and with the intent that the trust should be administered there. Next subsection, validity and administration under different jurisdictions. There is no irreconcilable difficulty in having the meaning and validity of the trust judged by the law of one jurisdiction and its administration governed by the law of another. Next subsection, the capacity of a trust company to take and to administer a trust is determined by the laws of its domicile. Next subsection, management. Practical considerations render it necessary the principle that no matter under what jurisdiction the validity of the trust is to be determined, problems concerning its management are referable to the jurisdiction where the seat of its administration is located. Next subsection, termination and revocation. Whether a trust may be terminated is determined by the laws of the state which was administered. Where a trust agreement provides for that the trust shall be executed in all respects in accordance with the laws of the law of that state governs revocation of the trust. D. Trust provisions as to state law governing. Where public policy is not contravened, the settlor may designate the state according to whose law the trust shall be construed. His intention should prevail if there is a real connection between the selected jurisdiction and the transaction. Where public policy is not contravened, the settlor may designate the state according to whose law the trust shall be construed. So he may designate a foreign law as controlling and establish the bounds in which such law is to govern the trust. The designation of the particular state, in combination with other circumstances, may control even though the settlor is domiciled elsewhere, or even though the settlor and beneficiaries reside elsewhere. The intention of the settlor should prevail if there is a common connection between the selected jurisdiction and the transaction. And this is true whether the settlor's choice of jurisdiction has been firmly stated in the trust instrument and is, therefore, directly provable, or whether his intention is deducible from surrounding facts and circumstances. The provision of the trust instrument that the trust shall be considered a trust of a specified state shall be governed by the laws of the state and cannot be construed to limit the powers and duties of the trustee to those granted and imposed by the laws of that state in effect at the inception of the trust, but subjects the trust to the continuous regulation of the laws of that state as they may from time to time develop. Next section, 161, Rules of Construction. In general, Trust instruments should be construed with reference to the particular subject matter, scheme, and plan, and the parties' relationship. The court must not, in the guise of construction, thwart the settler's wishes or make new agreement. It is a general rule of equity that once a trust is created, there is thereafter to be created as a trust, or treated as a trust. I'm going to read that again. This is under section 161, so mark it. Book 90. It is a general rule of equity that once a trust is created, it is thereafter to be treated as a trust. Now I ask the question, why is it that all of us talk about a straw man trust, but we never treat the straw man trust as a trust? Because corpus juris secundus says it must be treated as a trust. Continuing on. A trust deed takes effect when it is made, and the construction that will be given to it as the time holds true throughout the life of the instrument. An inter vivos trust speaks as of the day of the execution and delivery. The trust instrument is properly to be construed with the reference to the subject matter and its general scheme, plan, or structure, and the relationship or situations of the parties and the varieties of the situation. The court is not precluded from taking advantage of its own observations and the observations of people generally as to what frequently occurs to large estates. It is the duty of the court to interpret and construe the trust instrument as written. The court's duty is to interpret and not to construe, and it cannot be known to rule of construction thwart the will of the donor. So a court may not or will not arbitrarily attempt under the guise of construction to make a new trust agreement for the parties. It may not read into the trust instrument a provision contrary to the settler's wishes, or provisions which do not expressly appear or which do not arise from the plain meaning of the words used. Also, the court should, so far as possible, avoid an interpretation which would result in imputing malfeasance to the trustee. If future events do not accord to the settler's anticipations, the eventualities must be adapted to the terms of the trust and not the trust to the events. The possibility of the trustor may be alive at the time the gift fails should have no effect on the interpretation of the trust instrument. Whether or not the settler's understanding the effect of the trust instrument on his property and on his earlier will, the terms thereof, so far as they are valid, bind him and all under him. Next subsection, laws as part of trust. The pertinent provisions of the governing law become part of the trust as if written into it. Next section, letter and spirit of instrument. The letter of the instrument should be controlled by its spirit and purpose. Next section, date as which instrument speaks. A trust instrument must be deemed to speak as of the time of its date. Next section, the rule est justum generis is applied to the construction of the trust instrument only when the words to which it is applied are preceded by the words other or by a similar phrase. Next section, rule expressio unitas est exclusio alteris has been applied to the construction of the trust instrument. Next section, operating parts as governing. Where there is no lack of harmony between the rectal of the purpose of the trust and the operating parts of the agreement, and no ambiguity in either, the operating part governs and measures the rights of the parties. Next section, words of recommendation. When words of recommendations must be followed to carry out a clear intention of the settler, such words are regarded as words of command or direction. Next section, correction of mistakes or defects, transposition, where in order to advance an intention of the creator of the trust it is necessary to correct the mistake in a trust instrument, the court may make such correction where the creator himself may make the correction. Construing trust instruments, the court may, in affecting the intent of the creator, supply defects by implication. And in the presence of this course, courts may, if necessary, supply, reject, or transpose the words and limitations in order to get at the intent of the creator of the trust. However, it has been held that the court cannot transpose names in order to arrive at the settler's intention, and that it transposes words, names, or clauses only for the purpose of giving grammatical expression to the intention that otherwise appears from the instrument itself. Further, that it is the duty of the court to allow the indenture to operate as written without adding to or subtracting from its terms, and that no words are to be deleted and none added. B. Necessity of construction. If the meaning and intent of the trust instrument are clear and unambiguous, general rules of construction need not be resorted to. Where the meaning of the trust instrument is evidencing a trust is unambiguous, the instrument is not one requiring judicial construction or interpretation. If the intention may be gathered from the language without reference to rules of construction, there is no occasion to use such rules, and the actual intent may not be changed by construction. On the other hand, when the creator of the trust has so expressed himself that by giving to the language used the natural and unusual meaning, his intent is obscured. Resort may be had to the general rules of construction to determine the true meaning. The court may be required to construe an instrument creating a trust where the terms of the instrument as written violate the positive rule of law and are a variance to the rectal clause of the instrument, and whether in a particular case a condition is precedent, a condition subsequent, or a conditional limitation is prescribed is, in the absence of unmistakable language, a matter of construction. Next subsection, parole trust. Judicial interpretation is particularly necessary concerning a parole trust in order that after examination of all available evidence, an authoritative definition of its terms and conditions may be recorded in permanent form. Section C, application of general rules of construction. General rules for the construction of documents and written instruments, including contracts, deeds, and wills, apply to trust instruments. Broadly, the same rules of construction of interpretation of documents in general apply to trust instruments, and general rules of construction of written instruments apply to the construction of trust instruments, whether they are contracts, deeds, or wills. Instruments evidencing a trust are generally construed under rules of construction similar to those governing the construction of common law conveyances, and principles generally applicable to the judicial construction of contracts or other obligatory writings are pertinent or applicable. A trust agreement having the status of a contract, and the rules of construction used with respect to wills are alike applicable to the construction of trust agreements. However, in the courts of equity, in construing instrument establishing trust, are not governed by the technical rule of the common law, and those courts are not absolutely restricted to the rules of construction governing the class of instruments to which the particular declaration of trust may belong. Nevertheless, courts of equity may adopt the rule of law applicable to the legal estate unless an intent to the contrary is clearly manifested. D, favoring validity of effectiveness. Whenever possible, that construction of the trust instrument will be favored which upholds the validity of the trust and renders it effective. In construing the trust instrument, the courts will, however possible, favor the construction which will uphold the validity of the trust, where the intent of the grantor will be carried out rather than defeated, and which will render the trust instrument operative and effective, although this principle will not be applied in order to defeat just claims of creditors. Hence, where the provisions of the instrument creating a trust are capable of two constructions, the court will adopt a construction which will render the trust legal and operative rather than one which will render it void. For example, if the language used in a trust instrument is susceptible to two constructions, one of which will violate the rule of law, while the other will sustain the instrument and affect the intention of the creator of the trust, the latter will be adopted. Since such construction is presumed to accord to the actual intent of the settler. Next subsection, avoidance of forfeiture. Where two possible constructions of trust instruments, one would lead to the forfeiture of the beneficiary's interest in the corpus of the trust, and the other would avoid forfeiture, the latter construction must be made if at all possible. E, favoring beneficiaries or others. Generally, a trust will be construed in favor of the beneficiary and against the settler. Under most authorities in the construction of instruments creating trust, all intenements and inferences of law are in favor of the beneficiary of the trust and against the settler. An express trust whereby the donor of the trust estate dictates thereto all acreage owned in the name of the county will be construed most strongly against the grantor and most favorably to the grantee. So if there are any doubt or uncertainty in a trust, or if the language therefore is ambiguous, it will be construed, if possible, in favor of the beneficiary and against the trustee. So there's where we get the assumption of guilt on the trustee automatically in a court of equity. Let me read it again. So if there is any doubt or uncertainty in a trust, or if the language thereof is ambiguous, it will be construed, if possible, in the favor of the beneficiary and against the trustee. Bingo. That's under Section E of 161. Continuing on. On the other hand, it has been held that the deed of trust executed by the settlor for the protection and convenience of himself and his family must be construed in a beneficial, benevolent spirit, giving him every benefit of construction and resolving all doubts and uncertainties in his favor. Irrespective of a husband's motive in creating a trust which excludes his wife from the participation in the trust fund, any doubt as to the effectiveness of the trust in this regard has been required to be resolved in favor of the widow. Now, favoring present trust and vested interests. The fact should be construed in favor of a present trust, and an interest is vested rather than contingent. In determining whether a creator of a trust intended to create a present trust, the facts should be construed as strongly as possible in favor of such trust. Similarly, in a doubtful cases involving trust property, an interest or title should be construed as vested rather than contingent. So, since the policy of the law favors the vesting of interest, the provision will be construed as a condition subsequent to the preference to a condition's precedence. Next section, G, whole instrument or provision, surplusage. In general, a trust instrument must be construed as a whole, all parts being considered and each being read in the light of the whole instrument. Construing a trust, the whole instrument creating or declaring a trust must be considered in order to determine the settler's intent, and not merely any particular provisions, parts, clause, or phrases by itself. And consideration should not be given merely to the disjointed parts. All parts, provisions, or terms of the instrument are to be considered. Each paragraph, provision, or phrase must be read in the light of the whole instrument, and not in its isolation, and no clauses be given undue preference. The meaning of the part of a provision must be determined for the provision as a whole. 2. Giving effect to whole instrument. If possible, effect should be given to all language of the trust instrument, no part being treated as a nullity and no language being treated as surplusages. The trust instrument must be construed as to give effect or due weight to all its language where possible and where no rule of law is violated. So unless contrary to the obvious purpose of the instrument, or unless to do so would violate some positive rule of law, force and effect are to be given to every provision thereof, if possible, and like to all parts, so that the whole may be rendered effective. The court is not authorized to treat as surpluses any words used in the instrument creating a trust as long as their other course is reasonably possible. So no part should be disregarded or treated as a nullity, and no word, term, phrase, or part should be rejected as redundant or as meaningless. In the absence of ambiguity, or in any meaning can be given to which it is reasonable, be consistent with the rest of the instrument or with the object and purpose of the writing considered as a whole. However, the courts may hold particular words to be surplusages. H. Meaning of words in general. Words in a trust instrument must be construed as the best to effectuate the settler's intent, and they will be given their usual and ordinary meaning in the absence of anything to deflect therefrom. In requiring into the intention of the settler, it is important to determine the established legal significance of the words used. That the words used in the trust deed are ambiguous means that they are open to various interpretations. In ascertaining the intention of the creator of a trust, the courts are not confined to the strict and literal construction of the language used, particularly when such construction will frustrate the intention of the creator as gathered from the whole trust instrument. On the contrary, the words used in a trust instrument must be construed in that sense that will best effectuate the intent of the grantor or creator of the trust, and if possible, avoid the destruction of the trust. The determination of the settler's intent, the words will be taken in their usual, ordinarily, or natural meaning in the absence of anything in the instrument under consideration to deflect from that meaning, or unless the clear intention to use them in another sense can be collected, that other can be ascertained. It is true that the grammatical sense of the words used, words of the trust instrument are to be considered in a grammatical sense and their natural relation to the determination and intention of the creator of the trust, but the court will not adhere rigidly to the grammatical construction or a strict interpretation of the language where the effect of such adherence would be to cause an injustice. The words used in different parts of the instrument are presumed to have been used in the same sense. Conversely, where a settler, in creating a trust, aptly used meaningful words in some provisions and aptly refrains from using such words in other provisions for the city key belonging to another class, the use of such words in one case is not, on the other, has a significant bearing to the question of the settler's intent. Where it appears the words or terms of the instrument are used in their restricted sense, they should be construed in that sense. The words of the particular provision are not to be construed in vacuo or in its isolated grammatical phenomenon, but also to be read in their context. Next subsection, inoperative meaning. In the absence of an intent to the contrary, when the administration and not the creation of the trust is involved, words are frequently imperative in the meaning, although not in form. 2. Legal or technical words. Legal terms in a trust instrument are to be given their legal meaning unless obviously used in a different sense. In construing the trust instrument, where it is clear that words are capable of a technical meaning are used in a special sense, they will be so interpreted throughout unless contrary clearly appears. Legal terms in the trust instrument are ordinarily to be given their legal meaning unless obviously used in a different sense. Legal phraseology should not prevail over practical intendedness. Where the instrument has been drawn by one skilled in law, the presence of legal technical terms is an indication that the words are to be accepted in accordance with legal definition. But where it appears that the settler did not use legal words in their accepted technical meaning, and that he did not use uniform language throughout the deed, it serves no useful purpose to consider the dictionary definition of each word employed by him. Next section, I, repugnancies. If possible, a trust instrument must be construed to avoid repugnancy as by reconciling apparently repugnant provisions. A trust instrument must be construed as to avoid, if possible, all repugnancies. Repugnant provisions are to be considered and construed together, and if a reconciliation of the inconsistencies is possible so that provisions apparently repugnant may stand, a construction which produces that result will be adopted. If, however, the intent of the deed of trust is fairly ascertainable, parts repugnant or inconsistent therewith may be rejected. It has been held that no consideration of the provision of a trust deed will be adopted which holds such provision repugnant to grant so as to defeat the manifest intention of the grantor, and that accordingly words used in the habendum clause in the deed will not be permitted to defeat the effects of words in the granting clause. Notwithstanding the repugnancy thereto, it has been held that where the words are in a habendum clause which contradict words in the granting clause of the trust deed, those in the habendum clause will control, even to the extent of destroying the effect of the words in the granting clause. Better look up habendum clause and better look up granting clause. Continuing on. Next subsection, primary or dominant intent with or purpose. In construing a trust instrument where the reference to inconsistent or conflicting clauses, attention must be given to the primary dominant intent of the instrument or to its dominant and controlling purpose, and effect given to such intention, so that the clause should prevail which most nearly appears to be the intention of the donor and as gathered from the whole instrument. Next subsection, repugnant gifts, latter clause. If an instrument contains repugnant gifts in separate clauses, the gift contained in the latter clause shall stand. Next section, 162, intention of creator or settler. So here we come into intent. In general, in construing a trust, the settler's intention controls and is to be ascertained and given effect unless opposed to law or public policy. The primary or cardinal rule in the construction of a trust is that the court must, if possible, ascertain and effectuate the intention of the creator. So far as it applies reasonably certain and consistent with the rules of law, or consonant with the limitations of law, unless forbidden by law, public policy, or good morals. The intention of the creator controls. Construction of the trust or the intention governs or prevails, even if it's not inconsistent or in conflict with established rules or principles of law or some positive rule of law or public policy. But it has also been held that it is the language used which controls. So the intention of the creator is the guide primarily to the following in construction of the deed of trust, or in interpreting the intended effect of the trust instrument, and the construction enabling the trustees in their discretion to frustrate rather than carry out the settler's intention will not be adopted unless the language and tenor of the trust instrument admit of no other construction. The construction of the trust instrument depends on the truster's intent at the time of the execution, as shown by the face of the document, and not on any secret wishes, desires, or thoughts after the event. The paramount rule of construction is also held to be that, if otherwise legal, the intent of the parties is to prevail or to be given effect, notwithstanding any nomenclature to the contrary or unambiguous statements in the instrument. Such intent as the expressed intent is written. The cardinal rule of construction is to determine the intention of the settler, where the creation of the trust is a unilateral matter, and to determine the intention of the parties, where such creation is a bilateral matter. The court is to ascertain the settler's intention from the words or language used in the trust instrument, if possible, and to give effect to the legal consequences of the intention were ascertained, and the components, parts of the trust instrument are to be construed as to conform to the intention as ascertained. The language of the instrument may be a meaning controlled by context and surrounding circumstances. When an intention clearly appears on the face of the instrument, the court should not defeat the intention of any rules of grammar or rhetoric. Next subsection, questions of law. Under a statute providing that issue of law must be tried by the courts unless referred, the interpretation of the language used in trust instrument to express the intention of the parties presents purely a question of law for the court. Next subsection, of faulty or incomplete instrument. Notwithstanding a trust instrument is faulty, the court will endeavor to determine and effectuate the intention of the maker. The mere fact that the trust instrument is incomplete in one particular does not nullify the intention which is clearly shown. The likelihood that the settler intended to make an effective provision for all contingencies did not intend by mere omission to leave an interest undisposed of is entitled to some weight. Next subsection, where trust under deed depends on an agreement between the grantee and another, it is immaterial what the grantor intended. Next subsection, effects on parties immaterial. Without regard to its effect to the parties thereto, it is the duty of the court to interpret a trust instrument in accordance with the apparent intent of the creator. Next subsection, intent or activities of trustee. It is not the intent of the trustee, but that of the trustor that is to be given effect. Let me read that again. It is not the intent of the trustee, but that of the trustor that is to be given effect. And the activities of the trustee not participated in by or known to the trustor do not constitute any evidence of the intention of the trustor. Let me read that whole section again. Mark it. Intent or activities of the trustee. It's in section 162. It is not the intent of the trustee, but that of the trustor that is to be given effect, and the activities of the trustee not participated in by or known to the trustor do not constitute any evidence of the intention of the trustor. Next subsection, powers and trust. The intent is much regarded in the construction of the powers and trust, and such a power must be construed with greater or less latitude as would best meet the intent. Next section, B, numbers of trusts created. Whether an instrument creates one or more trusts depends on the settler's intention. as derived from its terms. Whether a terms instrument creates one or more trusts depends on the intention of the donor or settler, as it may be derived from its terms. So the fact may be throughout the instrument, all references to the trust are in the singular is indicative of the truster's intention to create by a single trust. While such terminology is not conclusive, yet in the face of such designation frequently repeated, indication of intention to the contrary should be clear. The intention of the donor or settler in this respect is to be gleaned from the whole instrument and not merely from the preamble, and the expression of the intention contained in the preamble must be disregarded if it appears that it has not been carried into effect by the granting clause. Next section, 163, liberal or strict construction. Authorities differ as to whether trust or provisions thereto are to be liberally or strictly construed. Liberal rules of construction are applicable to charitable trusts, which have been held inapplicable to private trusts, and a naked trust, in particular, must be strictly construed. On the other hand, it has been held that instruments creating trusts are to be liberally construed to carry out the intention of the trustor, and that the court should construe conditions liberally whenever it may be properly do so in order to avoid a forfeiture, or if the creator's discernible purpose would be thwarted by a literal and strict interpretation, but would be consummated by the liberal construction. It has been held nothing but equity so to construe the instrument as to realize that purpose. A strict construction of one provision of an instrument cannot be resorted to if such construction would render of no effect another provision thereof. Next section, restrictive conditions in an instrument setting up as trust are be strictly construed. Next subsection, trust deeds are not to be construed by the rigid rules governing the construction of ordinary deeds at law, and the deed of trust in the nature of a post-nuptial settlement to be liberally construed within the bounds of the natural and unconstrained imports of the provision of the entire instrument when considered in connection with the general scope and purpose. Next section, 164, construing instruments together. Two or more instruments relating to a trust may or should be construed together to effectuate the settler's intention, but particular instruments to be regarded as not so regulated as to require or justify consideration together. Where there are two or more instruments creating, defining, or relating to a trust, they may or should be construed together to effectuate the intention of the creator, as where the trust instrument incorporates another instrument by reference, in which case the instrument referred to will be construed as part of the first instrument, except to the extent that the incorporated instrument may be inconsistent, or whether the declaration of trust is made a part of another instrument. Among particular instruments, an absolute deed and a declaration of trust made as part of the same transaction may be considered together in construing a trust. Similarly, a deed of trust agreement may be construed together as part of one transaction and as establishing the trust. Likewise, a trust deed and a confidential writing delivered at the same time to be opened and read afterward may be construed together, as may conveyance of a trust and in reconveyance to the trustee, successive conveyances by the settler, the trust deed as one refers to the other, an original and a supplemental trust agreement, a trust instrument and a will, and a trust deed and an assignment of personal property. On the other hand, a trust instrument and a deed or a will of the settler may be independent instruments, differing essentially in character and purpose, so that they must be construed separately and not read together, particularly where the reading in an instrument together would result in the invalidity of their provisions, whereas separately considered there is no question of the validity. So where an irrevocable trust is established by a trust deed, it should not be construed together with the subsequently executed will of the donor. Where a trust deed does not follow the provisions of a will or refer to a will or in any manner indicate an existence of any other instrument, such deed must be construed according to its terms, and the deed of the trust cannot be construed by what the grantor said in his will, executed 4 days later, or in a codicil thereto executed 6 days later, where the deed and the will are materially different and presents different questions of law and construction. The language of the trust instrument cannot be interpreted by drawing inference from different language in the different instruments, setting up a different trust and executed in the same settler by the later date. The latter instrument is not admissible and an aid determining the settler's intent. Likewise, in construing and subsequently executed trust instrument, which expressly declares that all former agreements of every kind concerning the trust property are terminated, the court cannot consider a previously executed trust instrument, and in other circumstances, also successively executed trust agreements have been held not required to be read together as a single instrument. A trust deed may be held not to identify sufficiently any instrument as a grantor's will to which to resort may be had for a description of the land involved. Next subsection, instrument exercising power of appointment. Where a trust agreement provides for power of appointment, the instrument exercising a power is read into the agreement. Release. A trust deed is to be interpreted with the light of a release for which it was the express consideration. Next subsection, relation back. Where a trust is insufficiently declared and afterward the declaration is made sufficient by the grantor, the subsequent declaration relates back to the original declaration. Next section, 165, evidence to aid construction. In general, parole or extrinsic evidence may be admitted to aid in construing a trust instrument only if the instrument is ambiguous or uncertain, and only to explain and not to contradict the instrument. Not to contradict the instrument. Nothing should contradict the instrument that's being presented. Continuing on, in general, the meaning of the trust instrument must be determined from the trust instrument itself, and as discussed supra, section 162, it is likewise true of the intention of the creator of the trust. So in the construction of the trust, the purpose and intention of the creator must be determined from the terms of the instrument itself, and if it be plain and unambiguous, where there is no ambiguity, the language is clear and susceptible of one construction only, the plain provisions of the trust instrument must be determine its construction. Therefore, where the trust instrument is plain and unambiguous, extrinsic or parole evidence is inadmissible to show the creator's intent. In other words, the legal effect of the trust instrument cannot be controlled by oral evidence. Extrinsic evidence can never sever or to serve to contradict the language of the trust indenture, or to insert provisions for which there is no basis thereof. Nor is extrinsic evidence admissible in the absence of fraud or mistake to alter or vary the terms of the indenture. Thus, where a trust, its duration and the beneficiary under the trust are clearly expressed, parole proof cannot be received to vary or contradict its stipulations or to show that some meaning was intended other than which the words plainly import. Moreover, other instruments executed prior to the execution of the declaration of trust are inadmissible to prove intention. On the other hand, in the case of doubt or ambiguity, parole, extraneous or extrinsic evidence may be considered in order to ascertain the settler's intention, and may be proper in order to illuminate the circumstances surrounding the execution of the instrument and the settler's conception or understanding of any ambiguous words employed by him therein. So parole or extraneous evidence may be admitted to aid in the construction of an indefinite or ambiguous trust instrument where the effect of such evidence is to explain rather than to contradict the written instrument. Under those circumstances, the court may consider parole evidence to ascertain the duties of the trustee. Even though a statute requires that the declaration of trust shall be in writing and signed by the creator, parole testimony is admissible for the purpose of identifying either the beneficiaries or subject matter of the trust. And where the existence of the trust is shown by writing, parole evidence may be let in to show its terms. Moreover, parole evidence may be introduced to show the nature and the purpose of a trust and to explain an obvious omission or words inconsistent with the general intent of the instrument. Parole evidence offered for the purpose of lending aid to the court in construing the language of an instrument found not to be the genuine trust agreement involved is irrelevant. Subsection presumptions. Interpretation of a trust instrument may be based on presumptions where a sounder foundation is lacking. So in construing a trust instrument, any presumption indulged in must be one in favor of the validity of the bequeathed in the instrument, and the settler is presumed to have known the law and to have so worded his bequeath to give it validity. However, presumptions and prima facie concepts of constructions yield to the clear intent of the settler of the trust as evidenced by its provisions taken as a whole. D. Surrounding circumstances. The circumstances surrounding the making of a trust may or must be considered in construing it, particularly where the trust instrument is ambiguous or uncertain. Has been broadly held or the principle has been applied without qualification that a trust instrument may or must be read on the light of the circumstances under which it was made in order to determine the settler or the party's intent. So resort may be had to surrounding facts and circumstances in order to construe the trust with reference to the subject matter and purpose and the finding out the real parties and beneficiaries. Or the instrument is indefinite, ambiguous, uncertain, or inconsistent, the court can or must consider the surrounding circumstances in determining just what the intentions of the donor was or the meaning of the instrument. Among the circumstances to be considered are the relation of the parties to each other and to the property, and generally all sources of inquiry as to things which might have acted on the mind of the grantor. So where the trust instrument is indefinite, the court may consider from what source the money came with which the trust property had been bought. Section C, practical construction, conduct, or statements of parties. The practical construction placed on trust by the parties as indicated by their conduct or statements may be considered in construing it, particularly if it is ambiguous and under some authorities, only if it is. Concerning a trust instrument, the court may not only consider what is expressed in the instrument, but may also look at the conduct of the parties affected by the instrument in their performance of it, at least whether it contains equivocal language. And any construction sought by the party which would constitute a repudiation of a long-continued course of conduct is not regarded with favor. Hence, the settler's subsequent acts are to be held of a great significance in construing an ambiguous trust instrument. In ascertaining the intent of the settler, resort may be had to evidence as to acts or conduct under the trust instrument, at least if the instrument is ambiguous or uncertain. It has been broadly held that contemporary construction by those interested must be considered, and the courts should be given weight to interpretation placed on the parties on the instrument. Where there is an ambiguity, the court is empowered to consider the practical construction placed on the parties or the provisions of the instrument, and such practical interpretation of the parties of the instrument of doubtful meaning is of importance in construing it, or is quite pervasive in ascertaining intent. So the construction placed on the instrument by the trustee or beneficiaries is held entitled to some weight, although not controlling, and whether the settler provides that the trustee's decision to the terms of the trust and the interpretation thereof shall be binding because the settler's confidence in him, the trustee's construction and the interpretation of the instrument will be accepted by the courts in the absence of fraud or arbitrary conduct. Another authority, however, denies that the contemporaneous construction put on by the trustee should be given weight in construing the trust agreement. To clarify the meaning, evidence to the statements of the parties at or before the execution of the trust instrument may be admissible as bearing on the intentions, so oral statements of the donor both before and after the execution of the declaration of the trust may be considered, and the settler's declarations or conduct, whether prior to subsequent to the creation of the trust and his interpretation thereof, are admissible to be weighed in order to determine what may have understood by any ambiguous word as used by him in the trust instrument. However, if a trust is not ambiguous or of doubtful import, the practical consideration of the parties has been held to be of no importance whatsoever in construing it, and unless the parties have adopted an interpretation of the instrument to settle the meaning as between themselves of ambiguous language, there is no practical construction of the instrument. Where the intended meaning of the trust agreement is also is controverted. The statements of the assigners as to what interest they intend to transfer cannot be considered. Next section, 166, construction as to parties. Determining the parties to a trust, the creator's intention controls, and all the provisions of the instrument should be construed together as a harmonious whole. Determining who are parties to the trust instrument, the object is to ascertain and effectuate the intention of the creator. Therefore, a court of equity, in construing a trust with respect to the parties thereto, will not secure equally against the manifestation intention of the donor, nor will equity, in determining who are parties to a trust, overhaul a disposition which a man has made of his own property on the simple ground that the views of others a more proper and just disposal of it might have been made. Similarly, in accordance with the general rules discussed supra section 161G1, all the provisions of the trust instrument should be construed together as harmonious whole, and where there are repugnancies in the trust instrument, consistent with the intelligible portions thereof should, in ascertaining who are the parties, be construed together for the purpose of finding out and making effectual, if possible, the intention of the creator. Next section, 167, settler or creator. General rules of construction apply in ascertaining who is the creator of the trust. General rules of construction, as discussed supra section 161 through 165, have been applied in ascertaining who the settler or the creator of the trust is. And in fact, that the person furnishing the consideration is the settler is discussed supra section 4. There may be a real donor or creator of the trust, and also a nominal one. Next section, 168, trustees. Whether a person is a trustee depends on the construction of the language used in creating the trust. Whether or not a particular person constitutes a trustee depends on the construction of the language used in creating the trust. An instrument declaring a trust for a wife for life and then to children constitutes a trustee, one not only of the wife but also for the children. The conveyance of the property to a designated person, quote, as agent for the minor children, unquote, may, when such appears to be the intention of the grantor, constitute the grantee a trustee of the property in favor of his minor children. Next section, 169, city key trust. A, in general, trust beneficiaries are to be ascertained from the words of the instrument, giving effect to the trustor's intention, and if necessary, considering the surrounding circumstances. The ascertainment of a trust beneficiary depends primarily on a correct interpretation of the words used in the trust instrument, intention of the trustor's governing. If the trust instrument is indefinite, the facts and circumstances surrounding the parties may be considered in determining who are the beneficiaries, or analogy to the statutes of distribution may be resorted to for aid. More generally, the beneficiaries are identifiable by any competent and adequate proof. Generally speaking, rights are not derived from a trust in favor of one who is not a beneficiary. In order to construe a person as a beneficiary, the settler must manifest an intention to give him a beneficial interest. Unless there is such a manifestation, the fact that the person may be incidentally benefit from the performance of the trust does not make him a beneficiary. Persons who are not actual parties to the trust agreement may be expressly recognized as beneficiaries thereunder. If they desire to avail themselves of the agreement, they are bound by its terms as fully as the parties who actually signed it. Next subsection, give to class. If a person qualifies within the exact meaning of the language describing a class, he will be held to be a member of that class unless the language of an instrument expressly or by clear implication indicates an intention to the contrary. Under the provisions of a trust deed, a gift to a class owned either to a particular time or pending to a termination of preceding estate, only those take who are in existence at the arrival of the time of the distribution, unless the language used confines the gift to those in existence at the death of the grantor or at the date of the instrument. A settler's use of the words, quote, as would be entitled, unquote, instead of, quote, as would have been entitled, unquote, indicates his purpose to describe a class of persons in pro se rather than in esse. Next section, date of happening of contingency. Those who are to benefit from a contingent gift are to determine as if the date of the happening of the contingency. Next, an attorney who participates in the defense of one accused of a crime is not a of a fund which comes into the hands of the accused. Next section, beneficiaries as related to particular body. Under a trust in favor of named members of a specified lodge and all others who might become members of such lodge, the beneficiaries are not confined to the individual's name, but rather the aggregate body of the members who at the time of the conveyance in the trust or thereafter should constitute the lodge or society. Next section, beneficiaries named in insurance policy. Beneficiaries named in an insurance policy where the creator of the trust designates a beneficiaries as beneficiaries, thereof the beneficiaries of a specified life insurance policy. A change in the beneficiaries of the policy will work in corresponding change in the persons who shall be the beneficiaries under the trust. Next section, beneficiaries within particular areas, where a trust instrument designates as beneficiaries institutions as specified class within two specified areas. The beneficiaries are not restricted to those of a particular class within the similar area. A conveyance of land and trust for the inhabitants of a specified parish and their heirs to be used as a burying ground was for the benefit of the inhabitants in their corporate rather than that of the individual capacity. Next section, distributees under a will. Legatees or next of kin of the settlor may take nothing by the trust instrument which directs that the certain trust money should at the settler's death be paid to the executor or the administrator to be distributed in accordance with his will. Next section, employees of a specified company named as beneficiaries of a trust fund are those who were employed at the time of the distribution is directed to take place. Particular evidence has been held to establish that a person was within the employ of a trustor within the trust instrument, providing that he should be given property if he was in the trustor's employed at the date of the latter's death. Next subsection, parties of the third part. A trust instrument designated by name the wife, children, and grandchild of the settler as beneficiaries and referring to them as parties of the third part does not include within the distribution surviving spouse. Next subsection, persons or persons. A trust instrument providing for the payment of income to a daughter for life and directing payment of the principal by the trustee at the daughter's death to such person or persons as she may by will direct. The quoted expression is broad enough to include creators or donees' estates. Next subsection, person or persons legally entitled. As the quoted words are used in the trust instrument, the person or persons legally entitled on the death of the grantor have been held to be the heirs or distributees. Next subsection, personal representatives. It may be clear from all forms of elements of construction that the settler in a particular trust use the words personal representatives as synonymous with and denoting the next of kin and descendants, and not as meaning executors or administrators. Next section, persons furnishing aid. Whether a trust instrument limits the beneficiaries to those who furnished uncompensated aid to the contained corporation, to a certain corporation, persons who sustain losses through endorsing notes and purchasing stocks of other corporations with aided are not within its provisions. Next subsection, possible appointees under testamentary power may be excluded in determining who are the beneficiaries of a trust for the person what they have no interest in the trust pending the death of the settler. Next section, a remainder man has been held not to a beneficiary if a trust during the life of the life trust, but under other authority, the remainder man of a trust are beneficiaries thereof, as are the life tenants. Section B, children generally. We will stop there on page 43 under section 169 and pick up there next time. So let's open it up for question and answer. Then press *6, *1 to raise your hand. In the queue line.
Q&A session started.
All right, press *6, *1 to get in the queue line. Raise your hand for questions. State your name and where you're from.
Christian.
Yes, go ahead.
Yeah, I got in late. Where did you start at? Was that CJS 161 you started at, or was it earlier? Or was it 160 or what? That you were reading from?
We started in the new Corpus Juris Secundum book, but we jumped in starting on section, I think it was 160.
Oh, okay. 160 to 169 is what you read then.
Yeah. We skipped the first 159 sections because that basically has to do with a lot of stuff that we've already talked about before, so we'll come back to that some other time. We more or less picked up on the administration of the trust on section 160.
Oh, okay. All right. Well, that's what I wanted to find out, because I'm going to have to read that, because it's hard for me to pick it up just listening to it. I got to read it. Okay. Well, I don't have any questions right now.
No questions? Press *6, *1 to get in the queue line. Anybody got any questions?
Yeah, I was just going to make a comment, as long as nobody has a question. In the jurisdiction of the trust, where it's talking about the state that has the authority, then what we're looking at then is, being that we're private, then we are the state. We take the place of the state, I guess you could say.
Now you have to take into account that we're reading something that is post-1933, and it's all statutory, and it's all black in nature, and it's all public.
Right, I know, but if we were going to apply that to what we want, how it pertains to us, being in the private, then wouldn't that apply to us as being we're to be the law of the trust if we're the grantor?
Where is the law of the trust at? Is it on the public side or the private side? Because everything we're reading here is all the law of a public trust.
Yeah, but once we get into private, then that's where we are the law of the trust, right?
That's on the private side. Yeah.
Yeah, on the private side, right. Well, aren't we to take the black law and apply it to what we're doing? In other words, when you have something that applies in the public, can't you apply that in the private?
Oh, you're commingling.
No. I'm talking about as far as laws. I'm not talking about as far as being in other words, I'm not going to be in the public when I reveal the privacy, my privacy. But the law that would apply to enforcement of trust, that would apply to the private just as much as to the public, is what I'm trying to get across, I think.
It kind of depends on which way you want to look at it, because really the equity applies to the real man.
Yes, right. I understand that.
Real men are operating in the fiction. They're not operating as real men. They're operating as fiction. And then that private equity does not apply to them. It only applies to them under their real capacity as real men.
Mm-hmm.
And they got statutory equity that applies to the statutory fiction. But there's that duality. Most of the public is operating out of their minds.
Okay.
Being led by a brainwashing, a mind taking over with a public mentality, which is not private.
Well, yeah, I realize that there's a there's a private in the public, but when we're operating private in the private, then I know that applies only to the real man, and that's where you get your equity. And that's where our intention is to be, is in that private. So,
now, to what is the discernment between what is the actual real law and what is the difference between that and statutory law?
Well, statutory law is rules and regulations, but equity is that which is just and right for all men, and that's my understanding anyway. And
the laws and the nature of God. The laws of nature and nature's God. The laws of nature is equity, and of nature's God, that's common law. But what kind of common law? What kind of equity? 1933.
Yeah. Well, yeah, because we always want to make sure that we get our rights, whether the Bill of Rights or whatever. But we always want to get the rights of that God has given us, and that's where we have to go into equity to get that.
Have all the rights that God's given us. We've never lost them. We've just lost them in our mind. We still have them. We just don't recognize them in our own mind.
Right, yeah. Well, I guess I'm not expressing it correctly.
They can't even
You're right. I mean, I know that. We have everything that we were ever born with, and you're right. We haven't lost that. But in order to express it, I guess that's the hard part.
To express it, you have to know about it. If you don't know about it because you don't know what your rights are, then you can't express it.
Yeah, that's true.
You've lost them, although you still have them.
Yeah.
That's the mind job that's been pulled over your eyes to blind you to the truth, that you have all the unalienable rights given to you by God. That's quoted in the Declaration of Independence. Where did they go? Well, they've been forgotten because of the mindless brainwashing that you've been listening to all your life. Nobody knows the law. Nobody understands the law of nature's God and of nature's God and the law of nature and of nature's God. They don't understand that. And Jesus, when the woman was being stoned, many Christians don't get this. When that woman was being charged with adultery, the harshness of the common law demanded her death. Period.
Right.
But the only one who had the right to stone her that was sinless was standing right there with a stone in his hand. And why didn't he stone her? Because if he was God Almighty on the face of the earth, what was just and right, he should have thrown the stone. Now, why didn't he throw the stone? Because it was operating under another law form, and that was equity.
Right.
Equity said, oh, forget about killing her. We're going to go to a higher law form. We're going to go to equity, and equity allowed him to forgive her. It was maximum. He who does equity, he who casts the first stone.
Yeah, he who claims equity must do equity.
But that was an equitable maxim he was operating on right there. But nobody understands that. He who claims equity must be doing equity.
Right.
He who casts the first stone, he who's without sin cast the first stone. Excuse me, I got it all backwards here. That was an equitable maxim.
Yeah.
That's directly equatable to a maxim in equity. Now, everybody wants common law. No, man, if you want common law, you should be stoned.
Right. The law demands death. Exactly.
Yeah. You want to put yourself under the law and have your common law, you're welcome to it.
Yeah.
I want the higher law form. I want the one that operates under grace.
Right. I was just going to say, grace and equity must be the same thing then.
Absolutely.
Yeah.
Nobody gets that, even the Christians. Their minds are dumbed down just as bad as the other people. And they're satanic influence, and almost to the point they're not his spiritually at death, but they're his on the face of the earth because their minds are dumbed down. They're nothing but robots themselves. Worship commerce, money, creating liens, and NDIs, negotiable debt instruments. That's worship to Satan. We should not be doing any liens. No private set-off bonds. No, nothing like that. No negotiable instruments. No, nothing in Article 3. All we're doing is we're adding more debt. Debt upon debt, compounding debt, creating more sin upon my brothers and sisters. No, we need to stop this senseless, mindless games we're playing. We need to come to our senses. We just need to use this discernment. Romans chapter 12:2. Come to that pattern of world determination of what it is. Commerce. Transform your mind from that. Start thinking outside the box that that's all there is. No, it's not. There's another system out there. It's Philippians 1. There's a different accounting system, a different monetary system altogether. It's based on giving, not taking. Commerce is based on taking. Love is based on giving. You need a monetary system based on giving, based on love. You get me off on a tangent here. I'll start preaching.
Well, preach it, brother. Yeah, that's the whole paradigm shift from what we've been thinking. I understand that. But I guess it's just being able to express it, knowing it and expressing it. Sometimes there's a gap in there trying to do that.
Difference between knowing the path and walking the path.
Yeah, and I guess that's why when we do our little side things here, like I'm doing that telephone thing, and I have that court thing now. That gave me some experience in what I'm doing. Even though well, that's one thing that's good about trust is if you make a mistake, you can at least correct it. But where if you mess up in debtor creditor, then you can't go back and fix the recipe once the cake is baked.
Or wrong, and another wrong makes it right, or something else right on top of that makes it wrong still.
Yeah. I guess you made it clear what I wanted to get pulled out of there. But I need to read this myself so I can see exactly where we're going here.
Yeah, the book I have is 1855 copyright. I forgot to state that.
Oh, okay.
55.
Okay, very goodly. Well, thanks, Christian.
Okay. Also, I want to make an announcement. Next Saturday, I'm going to be changing the time on the beginning of Money, Banking, and Trust. It will no longer start at 9 p.m. It will start at 10 p.m. So next Saturday, look for it to be 1 hour later. That'll make all the calls starting at 10 p.m. Monday, Tuesday, and Saturday. The only one that will be different will be the 8 p.m. Eastern Time, which will be on Wednesday. So next Saturday, Money, Banking, and Trust will start at 10 p.m. Eastern Time. So if you come on the call at 9, we won't be here till 10. So mark it on your calendar. This is a schedule change from the Saturday show. It starts now at 10 p.m. Eastern Time. Anonymous, you're unmuted.
Christian, how you doing?
Who's this?
Marshall.
Marshall, how are you?
Doing all right. How about yourself?
Oh, just a trolling along.
Yeah. Good read tonight. Appreciated that. It was a good listen. Also, it was a real good listen.
What's on your mind?
Okay. What's on my mind right now is I have the thought in my mind. Equity does not. It looks through the form, the substance of a matter. So.
Yeah, it looks through the form, process, and procedures. In other words, it looks through all the at-law side, whatever it is. Looks all directly right through it. Comes back.
So now, that specific equity that's being spoke of there, that's private equity, is it not?
Yes.
Okay, all right, because that was where I was, I won't say I was hung up on it, but I guess like you mentioned, we got to go through the at-law side. We got to go through the gatekeepers first. That's where all of the forms and procedures and everything takes place, right?
Right.
All right.
Like the right key in the slot in the at-law side, and if you got the right key, you can turn the door and open the door, and now you're into equity on the private side.
Yeah, that's the way I look at it, because I know the maxim, and I have it in my head, and I know that it's private equity, but to get into private equity, you would try to make it difficult. Now, I guess that would lead me to my next question. Say mandatory injunctions and between the mandatory injunctions and the mandamuses and things of that nature, like with all of these forms and affidavits, and think about the affidavit is something that I'm about to speak about that, and forms, everything that needs to be.
Did we lose him? I think we lost Marshall. Michael, you're unmuted.
Hey, CW, this is Michael.
Hey, Michael.
Hi, how are you? You just mentioned something, and I think you might possibly be mistaken, but I thought I like what you were saying in regards to the reason why the Messiah, Yeshua, didn't stone the woman is because the other people were also sinners. But the reason why he couldn't stone her is because there was also another party at fault here, which was a man that also was committing adultery with her. So he couldn't fulfill the law because the whole law wasn't being addressed as both parties. So that's where the love of the law came in, that he couldn't stone her because it was an injustice, because she wasn't the only guilty party, and that the people, and then the people that were wanting to stone her might have taken part with her at the same time.
Yeah, well, when I get there, I'll ask him about it.
I think we all will, for that matter.
Yeah.
And I'm looking forward to that date. But the readings that you did tonight in regards to the trust, it really proved that we're really, really on the right track in regards that the trust takes priority over everything else once it's established. And they can't disregard it when we go into the courtroom at all. And that's what I got out of what you were reading.
Yeah, it's applying to the conscience of the court, yeah.
I thought it was very, very interesting, and look forward to further reading. Thank you.
Okay. You get Marshall back up? Yeah. Marshall, you back on? Yeah, Marshall, go ahead.
All right, once again, I don't know if this is going to happen again, so let's make this quick. Another thing that I want to talk about. Okay, now, hold on. First, let me go back to what I was saying. But temporary restraining orders, and can I go to vendors and get all of what I need to basically how it needs to be put together?
I'm not sure if it's in vendors, but it could be in there. I would imagine there's a formulas book out there. It's got some kind of examples in there, whether it be your...
Yeah. Last time I went to the law library, it was I was surprised. I never looked at that particular time, and I was surprised it wasn't put them size vendors.
Yeah, there's others besides that.
Yeah, there's a good couple of them that I should be able to look at. Next thing that I want to talk about, which is I feel is very, very important, eating the sex. Like you say, we left the line and how to create records of facts, and we anyway. When it comes time for enforcement, well, before we actually bills that we got to put in, the affidavit, which you told me about the affidavit was...
Yeah, we lost him again, I think.
You'd like to ask? Your request has been received.
Patrice, you're unmuted.
Hey, Christian, how you doing?
Okay, good. How about you?
Okay. I was just wanted to let you know, I don't know if you got it, but I sent you an email because I wanted to volunteer to do some transcribing.
Okay.
And I wasn't sure if there were, any higher priority ones that you wanted done, kind of quickly. But I was going to go ahead and just start and then just send them to you and have you look over them. And
yeah, there's a few that are probably a little more important than some of the other ones.
Okay.
Do you have a Skype handle you can give us so we can get back and
Yeah,
forth?
I'm already connected on your Skype. It's Catrice. Catrice.
I guess you already have a file. I guess you haven't downloaded it yet, so check it and see.
Oh, okay. Sometimes my internet access is kind of spotty, so it might take me a few days, but I'll get there.
Okay.
So, okay, I just wanted to say that. And also, I was inspired earlier this week to start a study. I'm going to tentatively call it Equity and the Word of God. But some of the stuff you were saying tonight, it lines right on up with what I'm going to be studying and writing about. It's kind of part of my call. I'm called as a scribe. Yeah, I really appreciated tonight and the stuff you were saying tonight and read. So.
All right, thanks.
All right, thank you. Bye.
Okay, next caller. Chris, you're unmuted.
Can you hear me? Hello?
Chris, you're unmuted?
No, I'm not.
Muted.
Oh, there we are. Hey, Christian, how you doing?
All right. Good.
What a week. I had 3 calls come from offices, secretaries of CEOs and CFOs in response to our testing the water.
Okay.
And we could talk about that later, but I just want to let you know that, whoa, they're calling me directly. A couple of other things I wanted to talk about, which just came into my spectrum of understanding this week, is easements. Easements seems to be coming up as a quick and fast-paced asset in our favor in regards to anything we do, and especially in and around indentures or trusts, that any time that a person doesn't ask for or does not do any diplomatic or ambassador channels to have easement to you and or your trust, therefore that's an immediate criminal trespass against the trust. And this is not just limited to a trust. This seems to be quite widely spread. When I went and found out this week that what was said on one of our private calls, of which some of the teachers or the ambassadors were part of this week, is that public officials are constantly trespassing their authority from one agency to another, and therefore almost in every given situation that they're citing and or charging and or engaging is a trespass to their authority, of which is, in some cases, it's a violation of copyrighted material, laws, codes, regulations, and from what I understood from the call, of which I did a little more research, it surprised me to find out that unless a county or a city has gotten the permission and a signed signature in a contractual relationship with the legislations that pass those laws, they are actually trespassing and are abusing copyrighted material. Therefore, they're impersonating the authority of what the original intent and the original copyright laws were set forth by the legislation without any form of contractual nexus agreements.
Okay.
The second thing I found out is I went back and, I was telling you about 2 or 3 weeks ago that there has to be an alternative to go into the DOJ about these issues, about the private equity stuff. Well, guess what I found out? I found out that HUD is directly related to FDIC. Both of them are like brothers and sisters or married couples, man and wife. What I found out is that the trust documents that I had posted for the ambassadors, this is the trust manual that has been issued out for all bank corporations and credit corporations to follow, is that the duties and obligations of the trustee or the CEOs of any bank institution, or what they would like to call themselves as the creditor or the lendor, of which they are not, we found out that if they don't have an explicit easement, a contractual relationship with either the IMF and or with the U.S. Treasury and or with the individual to act as a creditor, therefore they're impersonating a creditor, and that's part of the reasons why they don't show up in a bankruptcy when the creditor's meeting is set forth, is because if they're caught in that room, they would be admitting that they're a creditor where they have no nexus contract with either the U.S. Treasury and or the IMF. They can be arrested on the spot.
Okay.
And to come to the other end of some of the research that I found out this week, HUD in particular has private hearings. It's administrative, yet it's governed by a judicial hearing on civil rights violations and other issues, of where it is mandated. In other words, you have to request for a public hearing to take it out of the private. That means that every time that you solicit or you enter in a case, into HUD that it's always considered private unless you deem otherwise. And guess what? HUD is all equity law. And I thought to myself, well, wait a minute. You know, this is getting to be a long list of things that are just now coming into my...
What does HUD stand for?
That's the Housing Urban Development Corporation Agency under FDIC.
Okay, so it's a corporation, right?
Well, guess what? What else I found out?
Oh, wait. How can a corporation be private?
Well, it's a corporation of the United States of America, Inc.
I think, we'll find out there's two sides to a corporation. There's a public side and a so-called private side.
And that's the side that the private hearings. They're all private and they're under equity.
Yeah, but which equity?
Well, you have to determine that when you walk into the court. You set the jurisdiction.
Yeah, well, that's kind of like my point. If it's a corporation, it's public, and it's even if it says it has a private side, it's kind of like the courts are the same thing. So, but we still have the two kinds of equity. We want to make sure we get into the real equity to get the relief.
Okay, well, listen to the rest of it. This might help you. Under the duties and obligations under the trust manual that's issued out for all banks to follow by the FDIC that insures everything and backs everything in case there's a default or a foreclosure, that manual under duties and obligations for trustees to follow says that all CEOs and officers of a bank are mandated not to touch funds that are related to promissory notes. Therefore, all proceeds, fractionalizations, all interest, all payments are to be kept separate without dipping into the till. Therefore, each state, all 50 states, has their own escheatment laws that dictates that for them to have any charter or any doing business as within that state is this is a mandated prescription for them to follow, that any unclaimed funds are to be claimed through the comptroller and the state's treasury, and that by any chance that they deem that they're going to put claim to any of these so-called escheatment funds that are sitting out there, it could be easily construed as fraud, embezzlement, and tax evasion.
That's if they were using them
for their own purposes.
Their own purposes.
And,
I really don't think that they are. I think they are. I think they know what the law is. I think they're doing what the law says, and they're putting all these funds in trusts, and they're like passing the trusts around.
Well, that's easy enough to say.
They've effectively segregated them and kept them private, but they're keeping them private in trust, and then they're passing the trusts around like.
Well, that's easy to say, but when we put our claims in to have those funds retrieved, therefore, if they go into breach to us retrieving the funds instead of going to the comptroller or going to the treasury or going to HUD, if they fail to execute the merging of the titles and bring those funds back to us, therefore they're harboring and holding funds under the escheatment laws, of which now they can be prosecuted by the state.
Yeah, the whole key is you never ask for the funds back.
Yeah, and so when they fail to return those funds, then you have them locked in to walk right into the HUD and file a complaint that my civil rights have been violated, my trust rights have been violated under equity in private chambers with HUD, of which will initiate as the prosecutor to the comptroller and to the Department of Corporations and to the state's treasury to force their hand under administration without the DOJ, force their hands to return those funds.
Yeah, if you expressed a trust, claim the trust, and execute the trust. Because if you don't do it under trust, you can't do it. It won't work. So you got to claim and prove the trust, execute the trust, and then come and make your claim for your abandoned funds.
That's exactly right. And so, anyway, that's my little educational growth this last week I wanted to share with everybody. And because I was looking for an alternative than having to go to the federal court or doing a bankruptcy, although I've got those covered now. I've worked out all the formulas, and it's beautiful.
Chris, don't all agencies, all governmental agencies, have an administrative law form?
Every agency is complete unto itself. It has its own accounting office, its own treasury, it has its own law offices, it has its own administrative offices, and it is complete within a certain jurisdiction of authority that has been handed to them. They're completely complete.
You don't have the ability to do an Administrative Procedures Act judicial hearing.
That's right. Every agency has its own judiciary.
Yeah, that's what I thought.
Yep, it's confirmed. There's no doubt about it. Every agency is completely complete.
Courts are just acting like a separate entity, no different from all the other ones.
I think that the administrations are private. If you catch my drift, they are more private behind the scenes, because if you just stop and think about all the truckers, when they get a ticket, do they go to traffic court? No. You never see any diesel truck drivers in traffic court. There's a dead giveaway right there. There's your prima facie evidence that they're going to an administrative hearing that's private. It's not blasted in the public forum. Cash register court is always going to be cash register court. They're hoping that people are idiots and you donate money to them. That's what they're hoping for. But the administration, such as the DMV, under like the PC, that's Penal Code 853.7, on the back of your citation that you get here in California, it says you can request a administrative hearing, which is in the private, to deal with the probable cause issues of whether or not it needs to be referred to a DOJ. This is no different from one administration, one agency to the next. Every one of them are completely self-completed, of where if you just reached out and filed either complaints and or cases within those administrations, that you are more likely to have this privatized, completely separate from the public, and it won't be a cash register court of where you end up losing about 99% of your cases.
Right. So now the question comes back down to what we've been discussing for the last month or so. How do we get into a court of equity? And the right kind of equity, the private side equity.
And you know, if you go to the Corpus Juris Secundum and look under private, they've got 2 pages. It absolutely alarmed me to see that the Corpus Juris Secundum does not acknowledge or address private issues.
Yeah, because they call them special.
And, I'm going to do some more. Since I've got the whole volume now, I can actually do my own research and go and do my own investigation and whatnot. But I was, just to look under private, it's only 2 pages.
Yeah, they've hit it. Everything is either general or special. Everything is really under general by default, unless we claim the special. The special is the private.
Well, what really got me...
special, and see what it says there.
What really got me this last week is the fact that if a police officer pulls you over and he wants to cite you a state law, the first thing you can do is ask him, do you have easement papers to allow you to cite that law? And if he personally, or...
and I could probably prove that. It's not that the UPU grants you an easement. No, I grant them an easement. Because if they grant me an easement, they are over me. But if I grant them one, and not just the UPU, but any other entity, police officer coming to me, if I grant them an easement, I am over them. We have to be granting. We have to be grantors of everything. Anytime you take something from somebody else, that's a benefit, and you are under them.
Well, the way I'm reading easements is that if you're truly the grantor / settlor, especially under trust, and someone comes and trespasses that without consent, that could be construed as a criminal trespass.
Yeah, good, yeah.
And the way the UPU... Oh, I'm sorry, go ahead.
Did you grant them an easement?
At this point, no.
Well, yeah, really, because everything's supposed to be general, and under general, they don't. You don't grant an easement; they grant you one, and they haven't granted you one.
Well, this is my point with the UPU, is that the UPU says that admiralty and a compromise of a country to surrender their sovereignship means that they're under general law, but because they can't realize and acknowledge or even address issues of the sovereign nations, of which that's the part that has to be surrendered in order to be a partner with the UPU, is that is special. Being a sovereign is the special part. Therefore, anytime anybody that's part of the UPU, anytime that they encroach in on the sovereign, which is the private side, then that's automatically an easement violation and a criminal trespass to the private side of life, the sentient man.
Who does the enforcement? The UPU?
Well, we're learning how to be that, because we are the sentient beings, and because of what I've heard in the past with Keith Livingway, and that's moving forward. It's just amazing with the shifts and changes that are going on in my mind and how I deal with life. It's just amazing. Just the idea of easement. If everybody just stopped and thought how beautiful just the consideration of easement and how that really sets up your trust relations with the whole world. Just easement by itself.
If my boundaries were not in anyone's jurisdiction to where they would even need an easement, how would they be even, say, trespassing them?
Well, I've got an example. I saw a lady, and I asked her why. I walked up to her, and we were all friendly up to the point of where I realized that I had violated her, but that was an inadequacy on her behalf. But I asked her, I says, well, hasn't the fire marshal contacted you about all your weeds being 4 feet high around your house? She says, well, how dare you even make anything, blah, blah, blah. And all of a sudden, I looked at it from the easement point of view that I had trespassed something that she was extremely sensitive to, maybe inadequate emotionally about it. But the thing is that it's so easy to trespass on another person's easement regardless if they're inadequate about it or not. And I realized that what I need to do is I need to remedy the situation, of which I told her, I said, well, I didn't mean anything by it. I was only, kind of joking around with you. And she finally realized, oh, okay, well, then at that point. But it's so easy.
Let's use that example there. Let's say that woman's property, she took the boundaries of that property and put that in a total different venue.
Mm-hmm.
That wasn't even in that jurisdiction any longer.
That's right.
Now, if you came on her property there, how could you have violated her easement?
No, it was the comment that I had made about her weeds and about the fire marshal, putting a red tag on her house.
Really, the comment would have been if it was not in the jurisdiction there because she pulled everything out. Then even if you made a comment about it, she wouldn't really have to worry about anything because she knew that it wasn't even in the jurisdiction. And your comments didn't hold any water.
Yeah, but she wasn't that mature. That's the problem.
I'm using that as an example. What I'm trying to say is that it's very easy to change the boundaries, which is really one part of the identity. And the identity is the essential thing. Because identity consists of 3 parts: name, boundaries, and whether it's public or private. So if you change it to private, you define the boundaries, do a resurvey on the boundaries, and you take the name and you pull all 3 of those out. You've pulled out the identity of the thing, which is the res, and now it's no longer in the jurisdiction. Change the venue. My thinking is, I don't even need an easement unless I want to grant one.
Well, I mean, and it's okay for diversity and for people to think differently. And I'm like a kid in a candy shop right now. My investigation.
Here's the thing. We want the red jelly beans. And we go into the candy store, and oh my gosh, there's these, and I grab them, and I grab this, and I grab that, and then you come back out, and okay, where's the red jelly beans? You know, I got so much candy, I forgot the red jelly beans. Now, we either take the red pill or the blue pill.
Mm-hmm.
Take the red pill, we can't go back, and everything changes. Or if we want to take the blue pill, we just wake up and go on with our life the next day.
Well, I think my point, and you probably agree with it, because I'm not looking for adversarial considerations here. When you do a survey in order to create an indenture, you have to know exactly what it is that you're going to survey to create that indenture. You have to know that you're not going to trespass other people's rights or other people's property, and or if there's any controversy, even what you're reading tonight, and I went ahead and read the rest of it on the children's thing. Very fascinating. It has everything to do with the age and majority, by the way. But going back to what I'm saying is that when you set up an indenture or you have an intent, you have to be somewhat cautious about not trespassing easements with other people's rights or their property. So therefore, when you set forth any kind of an indenture, trust, you cannot include trespassing on other people's so-called trust res. So easements... easements and surveys are an appropriate set of words that should be in everybody's vocabulary that's setting up an indenture or a trust. That's my point. And like I said, you know, I wanted it to be a compliment rather than something that was adversarial, only for the fact that I do claim myself as a teacher, and I do want to teach people to expand their horizons, and I still want to compliment everything that you're doing. But easements and surveys and putting the indentures and trusts together seem to be very important. And, you know, I mean, they're certainly important to me.
A knowledge of boundaries and identity and what that consists of.
Exactly. What is your intent? Do you have intent to trespass somebody else's rights? No. Okay, so my intent is to stay within a certain survey, a certain easement. That means that I'm harmless. I don't want to encroach on other people's spaces. Therefore, I have to write that kind of language into my indentures or my trust. But nevertheless, I had fun this week. Oh my God, I can't believe how much stuff me and Eric covered. We didn't spend as much time as I really liked, but we did go over some details and some papers and stuff like that. We did go over to the law bookstore, and we ended up buying some books that are very pertinent. I know that we didn't get the 30A, the CJS, for some reason that seemed to elude the bookstore. Out of hundreds of thousands of books, we didn't have one 30A that came about. So, yeah, I know. But I found them online. There's used books that anybody wants to buy them. You can go online and look under CJS and then put in 30A as a used book. And I found several sites the other night that you can buy them. They're about $25, $30 for those books, by the way. But I think that's pretty much it for me. Are we having a teacher's call or an ambassador's call this evening, or is that going to be offset for next week?
Next Saturday, yeah.
Okay, all right. I just wanted to be clear about that. But
Monday. Next one, Monday.
Okay, the next one's Monday. Going back to HUD, what do you think about that with my findings on that with HUD?
Yeah, I've always thought that, you know, all of the administrative governmental agencies have an administrative side. You could do the Judicial Administrative Procedures Act.
Well, my idea is if you're tying in a breach of trust and that these guys are violating the escheatment acts of the state, therefore the state has every right to challenge or to investigate these banks of why didn't you bring these funds forward for this person to put them in a special account? And this still, in essence, it bypasses having to do bankruptcy or even trying to get into chambers with a federal judge, and you're doing it within the state of which that is their duties and obligations and their authority to be doing this kind of activity.
Yeah, but my point I was trying to make was that it didn't make any difference what agency you had. You didn't have to go to court. You could have gone through the agency, and the agencies would probably do an Administrative Procedures Act with the judicial judge. And there we're on the same things as Administrative Procedures Acts, getting into equity again, probably under the same procedures that we would as if we were going through court.
Mm-hmm. Yeah.
I don't think it's going to make much difference, although we have much more plethora of available court or dib hearings now, because all administrative agencies, all governmental agencies have administrative side and have ability to do a judicial hearing and get into equity.
Well, one of the things that I found out inadvertently to my research this last week in and around the subject matters we're speaking about is that part of the reasons why 90% of all the RICO and racketeering complaints that are put in at the federal level are denied is because they have not been referred by the authority of the agency that handles those issues that would refer that to the DOJ. In other words, you got to get the blessings of the agency that is their authority over that subject matter. And if you bypass them, you're basically trespassing and violating the administration, and therefore you're denied. You're considered a trespasser by trying to put a criminal complaint in by not including them with their investigations for them to refer to the DOJ.
Right, and it was all done generally anyway.
So, I mean, this week has been power pack. It's just, it's just leaps and bounds at this point, Christian. Leaps and bounds. And it's all about me staying with you for the last 7 months and really staying intently with what it is that you're explaining. Everything fell into place. Everything fell into place. And that's the reasons why a lot of this stuff continues to fall into place. I realize and recognize that, oh my God, there is definitely a private and a public side to every agency, right down to the U.S. Marshal.
Yeah.
So we're really on to something, and I think we're going to get some results here soon because we're starting to get the attention of the banks. I'm not used to CEOs calling me up on the phone, wanting to talk to me. It's like, well, what do you want to talk about? Of course, Eric says, well, why didn't you ask them questions? Find out what they wanted. I says, well, if they can't put it in writing, there's no sense in doing any hearsay on the telephone, But anyway, that's pretty much it. I'll chime back in if I've got any more. But yeah, it's been one dynamite week. I'm just really, really happy with the results this last week.
Okay.
So why don't you go ahead and flag in somebody else, and I'll get off the line for a while.
Thanks, Chris. Next caller, you're unmuted. Marshall, you're back on.
May now ask your question. Muted.
Marshall, you're up. We can't hear you.
Hello?
There we go.
All right, I had it on mute. Thank you. I appreciate that.
Okay. Where were we?
Okay. Yeah, I'm on Skype now, so no more cutoffs. Everything should be good now. Now, what I wanted to talk to you about again is, for me, it's very important to know about the facts, pleading the facts inside of your case, and not traversing into their argument and the tricks and the many, many ways that you can just blow your own case inside of a courtroom when you're doing your enforcement. So I guess I just want a little bit of advice on what to look for when it comes to that. Now, when you say stick to your facts and stick to your pleadings, that would I don't think that would be hard to do. I think the difficulty, or probably just because I need to know a bit more about it, for me the difficulty comes in when it comes times to answering their questions or whatever it is that they're throwing at me, my conditional acceptance, I should say, to come back in with my bill and my facts that I'm pleading. You understand what I mean? Or am I explaining it right?
Right. You know, how to switch the game back on them and bring them back to the fact that you're arguing your motion instead, your counterclaim, say, rather than their claim.
Exactly. That's right there is important, because as much preparation that one may do when it comes to their paperwork and spending so much time reading, and all of that is important. It's a cornerstone for everything that we're doing right now, but then all of that can be right out the window in a matter of seconds if you don't know what to look for and the pitfalls and the traps that these people use every single day. So I think it would start by one having just examples to be able to build off of. At least that's how my brain works, because I know there are certain things, certain situations and questions or something that they may say to me that I would know how to respond to. But I guess I want to be more sharp in it. And it's important because, like you say, you can go in there and be in equity, and then next thing you know, in a blink of an eye, you're at law because of something that you did, one of your actions, your deed.
Yeah, you can always stick to when they ask you a question, if you would come back and say, you know, where is that in the pleading?
Right.
If it's not in the pleading, you can't talk about anything outside the pleading.
Okay, see, it's those little simple things like that I need to know that makes sense to me. Like, if it's not in the pleading, then we don't need to be talking about it at all.
Right. So if your counterclaim is not about their claim, then why are we talking anything about their claim?
Right. And as much as they may try to enforce something like that, or say like I hear about this 3-strike rule where, say for instance, a judge would say, try to have a rebuttal for whatever it is that you may say to him, and he ignores what you say the first time, and you have to stand your ground, and he go that second round with him and then stand your ground again, and even if he's threatening contempt.
Yeah, but that's a game I really don't want to get into, because, you know, I really want to I just want to be in that court long enough to open the door into equity, and let's just get into equity. Let's set the boundaries of equity. Let's get on with the equitable side of this.
Okay. All right. Those are the small little connectors that I need to place one point to another.
It said basically that it's when the onus of probandi shifted and the trustee was assumed to be guilty.
Right. So now,
if I make a prima facie case that there is a trust, now I'm in a whole different law form right from the start. And it should be automatically assumed that the trustee is guilty. And they shouldn't be going at them. The whole demure of the court should change, because now you're no longer the defendant, you're the plaintiff. And the trustee, who is the plaintiff, say, is now assumed to be the bad guy. And the way that you treat you as the defendant, now they must treat him that way. So you should be preferential treatment.
See, now, that is my thoughts exactly. Coming in with your counterclaim, or whether you're the plaintiff from the start of it. Either way, when you get inside of that courtroom, if you do it the right way, you will be the plaintiff, and your adversary would be the defendant as the trustee. Now, of course, that's the way it was supposed to be, and the plaintiff is supposed to get the treatment, as the preferential treatment, like you just said. But then again, I also know that a lot of these judges are in the bankers' pockets, and they do their best to get you back on the other side and get you to open up and traverse back into their facts. So, like I was saying, everything is in regards to equity and how it should run. I'm aware of that. Well, I won't say everything, but the basics of it and how to get into equity and how equity should deal with my equitable rights once I make my prima facie case about it or my bill. Is just that I just want to also be prepared for the crookery that goes along in there also. Now, if I was...
Crookery is because they don't know what the rules are to hold their feet to the fire, so they can't do those things.
Right. But now when you put it like that, it's actually not crookery. It's just us not knowing the procedures all the way through.
Right.
I totally agree with that. Totally agree with that 100%. So now...
When the plaintiff's attorney starts testifying, you can shut him down in an instant because he's not a competent first-hand witness.
Right. Okay. Something that came out last night that you had told me about is when we put in our bills or our pleadings, well, I like to call it bills. When we put in our bills, the bill, one thing that I want you to explain a little bit more to me is the affidavit that goes along with it. The foundation, you called it, and when you said it it clicked in my mind like he's absolutely right. And I say that because when I was in debt creditor, I remember attending this webinar, and it was a gentleman who was speaking about the fact that when we get, say, traffic tickets or whatever type of summonses to go to court, he made a point and stated that it's basically fraud on its face because it's not a verified complaint. Like a plaintiff has to have a sworn affidavit stating some type of an injury. So if you get a traffic ticket or something like that, there is nobody stepping up to say, okay, well, I was injured by this person by doing 90 miles an hour or whatever the case may be. So when you said that to me, it just made perfect sense, even with our bill, that the bill has to be accompanied by some sort of a sworn affidavit, stating the facts, right?
In support, yes.
In support of it. Okay, see, now that's important because that's one thing that I can admit I never thought of. I thought it really started just with the bill itself, and that kicks off the entire proceedings, which in a way it does, but then it has to be accompanied by a real affidavit. Now,
yeah, the affidavit is acting like the SOI, but really it's a public notice pointing to an actual competent fact witness that can be put on a witness stand and cross-examined.
Okay.
And the complaint or the bill, that's an NOI. The night an SOI.
Explain that part again where you just said about putting the witness on the stand to testify. Now, if I'm doing a written document, I'm trying to tie that together. Explain that to me again, please.
Well, the affidavit is a prima facie device that sets up. It's not actually the affidavit itself, but it's supporting the statements and the pleadings and verifying them to be true. But it's going to come later on because that's only pointing to a real competent fact witness that can be put on the stand and give live testimony, first-hand knowledge based on information and belief.
And that would be me.
That would be you, yeah.
Exactly. Okay. All right.
There always has to be a competent fact witness, not just a piece of paper.
Right.
Okay.
So in the proceedings, say if you're going for a mortgage situation or a collateralized loan, say hypothetically, the banks would never be able to come with a competent fact witness because everything the attorney is going to be saying is all inadmissible because it's hearsay. And if he was to try to put one of his experts on the stand, it would be basically the same thing, wouldn't it?
Yeah, usually the complaints that the attorneys put are not verified. They're not sworn to. And they don't even have any affidavits swearing to make it valid.
Exactly.
All they do is attach copies of other documents, and some of them aren't even original.
So what happens?
Nothing.
So then what happens is basically we give it life. We give it the validity then when we don't, say, object to it or
Yes,
come
right.
in with our own counterclaims.
Objection and opposition, right.
Right. Okay. All right.
An objection is an NOI again, and then an NOI that is not substantiated with an SOI, that objection will be timed out.
That's right. So if you just say objection, and then the judge looks at you like, okay, you're objecting to what? That's your NOI. Your SOI would be, I object because of such and such and such.
Right.
Okay.
Everything in court operates on an NOI
And an SOI.
Kind of like a leapfrog game.
Yeah, exactly that.
Tennis match. And if you know how it's played, it's really simple. Because they're going to say something, and that's an SOI. Now, if they don't have an SOI to support that NOI that they said, then you could object because it was unsubstantiated by an SOI.
Right. So
you're stricken them.
So basically, bringing it back to what I was speaking about earlier. If they do try to get us to traverse back into an at-law situation where we losing our equitable rights just because of our own actions and deeds, basically if they was to come at us with something, our NOI would be that has nothing to do with my equitable pleading, and my SOI would be my equitable rights that I would be speaking of in a maxim, right?
Right. What you're having problems with and what you're really asking is, how do I make the pleading colorable enough to make it recognizable in their venue, but not put in too much truth that will be waiving it all?
Right.
And that is done by the notices. Because
right.
The notices take a substitution of an actual SOI on a private. When it says SOI on the public, that's what a notice is, pointing to the actual evidence being on the private.
Okay, all right.
Put in your UCC 1s and your 3s to prove that there was a trust. And then to look at the actual information, the facts, we got to have an evidentiary hearing in chambers.
So, okay, so now bringing it all together for me. See, like I always say, there's a lot of this stuff that we talk about. I know it, and when I ask the questions to you, some of it, a lot of it I don't know, but a lot of it I do know. And the reason why I still ask you, because you always say certain things that makes it make more sense to me. So I thank you for that. So now, for the pro se litigant now, laws and procedures as far as in the at-law side when we're dealing with the gatekeepers to get into private equity. Okay, the procedures are in the books. How should I say it? The procedures are in the books, and exactly what to do and how to put it together is not. I don't understand that. Like, for instance, a letterogatory, if I wanted to put something like that together, like, where would I go to even know how to begin to do it? Because I'm at law, and the procedure and the form is critical here. See, this is why I'm not one to say take somebody's paperwork and just carbon copy it. Like, I want to know how to put it together myself, and
right.
I just need to be pointed in the direction on what I need to read from their books, from their procedures that they sat down and thought of and said, okay, in our system of commerce and laws and procedures and forms, this is the standard right here. Like, wherever they put that is where I need to go. So, like, that's what I'm asking you. If you could give me a little bit of advice. I know I got the forms book from vendors and the other ones that's in there, but there's other critical pieces of information that would need to go along with our pleadings and things of that nature to jazz it up and strengthen it up a little bit, because I've never seen any book speak of a letterogatory in a way of putting it together. You understand what I'm saying to you?
Yeah.
So I asked that because I really want to learn how to put this stuff together myself. It's like something that I'm really, really interested in doing. So besides the vendors, is there anything else that I would be able to do to get myself on the right track?
I don't think there's going to be a whole lot of stuff that in modern day times is going to be written. Some of that older stuff, like early 1900s or before, is how we used to do government, and that's really pretty basic. If you've got that old banking, United States Bank thing that we had, that 4 pages there, that's basically how they did government, because they just did an advertisement in the newspaper, and they had witnesses or notaries validating things, and once it was in the newspaper for so long, you know, it was uncontested, and it became law.
Right.
And that's basically how we do government on the private side. So a letter of regulatory is nothing more than just communications between 2 jurisdictions, 2 courts, say, one foreign to the other, and they're just informing each other according to maybe some kind of basic formalities that, you know, is not that hard. And it's just really just a letter.
See, that's what I'm talking about right there. You see how you just gave me that very simple definition of it? Like, now me, I'm able to take that little piece that you just said and pick that apart and create something like that. That's what I'm talking about. Like, I just need that small little guidance and that, you know, push in the right direction, because I can read the definition of letter rogatory inside of the Black's Law Dictionary if it's in there. I haven't personally looked it up, but I will now. But it'll give me the definition, but it won't explain it like how you just said. It's basically just a letter. It's a communication between 2 jurisdictions, and for instance, we're coming from an equitable jurisdiction, so if we're dealing with a judge, which is in an at-law jurisdiction, then we would want to have a letter rogatory to communicate with him, right?
Mm-hmm. Right.
See? All right. Simple as that's what I'm talking about right there. See? All right.
The rogatory could act like the mirror image of your bill in equity on the private side, or excuse me, on the public side.
Wow. Okay. All right.
And your indenture, say, of the trust, is going to be kind of like the letter rogatory itself, too, or a part of it.
The fundamental rule that in all equity pleading that no bill can be sustained which does not have its foundation one or more have which does not have as its foundation one or more of the grounds of such jurisdiction. This jurisdiction results from the inability of courts of justice to afford adequate relief in particular cases on account of the great variety of complex relations between men entailing duties and obligations of which could not be enforced at common law. The Judiciary Act of Congress 1789 provides that suits in equity shall not be sustained in either courts of the United States where a plain, adequate, and complete remedy may be had at law. So now, going back to making it just colorable enough for them to see it, but still get us to recognize it at law, but still get us into equity. Now, how do we know where to draw that fine line?
I was on a chat call with some trust ambassadors, and we went over like seven things.
Okay, well then I have to get that call then. So you don't even have to go into it right now. I'll just get the call and listen to it and take notes from that. Great. For right now, I think that's it. Oh, no, one more thing. If you could explain something for me real quick. I was reading inside of the, which was it? I think it's it's the equity pleading book. It says the incapacity to sue in equity is of 2 kinds of absolute and partial. The only instance of the former is that an alien enemy, that is, a subject of a country at war with the U.S., who is absolutely debarred from the privilege of suing in our courts, so long as he continues in that character. Now, let me read it again. The incapacity to sue in equity is of 2 kinds of absolute and partial.
The only instance of the former is that of an alien enemy. That is a subject of a country at war with the U.S. who is absolutely debarred from the privilege of suing in our courts so long as he continues in that character. Now, a citizen, isn't a citizen considered an enemy of the state in a certain way, like an enemy to the United States? I've been a little unclear about that.
Yeah, a citizen straw man is an enemy of the state, yes.
Okay, then. So now, being what I just read right there, as long as we have ourselves misconstrued as citizens, then that in itself would debar us from using the courts if they really wanted to get technical, right? Because there was no re-expression of our, how should I say, status.
Yeah, that's kind of like, if I can get into the equity side, that won't make any difference.
It won't make a difference. Okay, exactly. But then to get into the equity side, like you say, we got to go through the gatekeepers first. Now, if we're going through the gatekeepers, with that being said, we would have to change that status. Would that not be connected to the IMF file?
Well, remember what it said about equity? It looks through the form, the substance, the it looks through the form, process, and procedure, and goes to the substance.
Okay. It's going to bypass all of that. See, when I hear stuff like that, I always think about private equity. Okay, when we get into private equity, it's going to look through the form and bypass everything. But then to get there, once again, we have to go through that.
The court is probably our pleading that we put in there has to contain all the switches necessary to throw the current into equity.
That's what I see. Once again, I just needed to hear that one small part right there. Everything goes back to our pleading and that affidavit and us setting our law form and doing it in a way where we're basically not giving them too much room to breathe. Like, do what I tell you to do, basically.
Yes, like I'm not asking for any damages, which would be at law. I'm not commingling one side at law with the equity, and I'm sticking solely with equity. Trust automatically in equity. Counterclaim is automatic equity. You know, no adequate remedy at law is automatically equity. You know, I'm putting all the automatic equity things in there.
That's right.
No way that they can misconstrue this to be anything other than equitable.
That's right. That's what I'm talking about. Exactly. All goes back to that pleading. So we got to put together a strong pleading to get our relief.
Yes and no, but I just want to put enough in there to invoke equity, have the switches necessary, and then abandon that public pleading. Then I'm on my equitable in the private side, my letterogatories, my SOIs.
So in a foreclosure action, if you was to invoke a court of equity, wouldn't it be just and fair for an equitable court to automatically put, say, like a stay or a temporary restraining order on a foreclosure action or proceeding?
If you can demonstrate that you're being prejudiced or being harmed irreparably, then, a stay should be enjoined.
Right. Okay. Now, but I get my question that I'm asking is, can we just make mention of that in our bill or in the facts? Like
you have to have the elements necessary in a TRO or the enjoining action to get it. In other words, you have to do their form, process, and procedure to get the color to give a colorable injunction.
Right. Okay. So got to get through the gatekeepers first. All right. So equity is not just going to automatically do it. You got to do what they require for you to do in order to get that done.
You got to learn how to hold both sides of the court
at the same time. Yeah, you've been saying that for months. Precarious rights. The right which the owner of a thing transfers to another to enjoy the same until it shall please the owner to revoke it. Precarious right. Now, when we putting together our pleadings and things of that nature, like, when we want to be using that type of verbiage, because I have a good list of some words that I come across in the readings, and like I told you, I take your advice when I go through certain books and readings, and I look at their verbiage as the same verbiage that I'm going to use because it just makes sense and it sounds powerful. So now, say for instance, a precarious right. I've never heard that before until it came across me in the Black's Law. Wouldn't we want to use something like that, or does it make a difference?
I don't think it would be a precarious right. I think it would be a special right or a special privilege. Special. Next
Okay.
Special circumstance, special right.
A special right. I was just about to say that. Okay, but I just took the dictionary meaning of it, where it says the right, which the right, which the owner of a thing. I'm looking at thing as like res property, transfers to another. We move titles, we transfer all kinds of things to enjoy the same until it shall please the owner, which is grantor, to revoke it. Is it not the same thing?
Yeah, but that's kind of feudal sounding to me, because that's like if the grantor can revoke it, then he didn't really give you all the rights.
Right. Okay. You know, I'm glad I asked you that, because it just sounded like it was something. Yeah, you're right. It does sound feudal now that I'm thinking about it. Precarious. Sometimes I just go through Blacks and I just read
Sounds
it.
like off meant to uses to me.
Say that again?
Sounds like see off meant to uses to me.
Yeah. Okay. I could definitely understand that. All right. I think I've been on long enough. I'm sure there's other people that want to get on and ask you some questions. I appreciate it. You brought a lot of things home to me, and if there's anything else, I'll come right back in. Like I said, not scared of getting cut off no more. Appreciate it, Christian.
All right, great. Thanks.
All right.
Oh, you're unmuted.
Yeah, Christian, I was wondering if I could get on that Skype handle.
Yes, sure. Go ahead. Give us a Skype handle.
It's O-M-E-T-O. Palmetto.
Palmetto?
Yeah, it's with one T instead of two.
One P instead of two.
Right.
P-A-L.
M as in Mary. M-E-T-O.
Oh.
P-A-L-M-E-T-O. Palmetto.
You're in Florida?
I'm in Nevada.
Oh, okay. You got palmetto bugs down there too?
No, we got palmetto palm trees though.
Okay. All right. Anything else?
No, I was just wondering if I could do that.
Sure. Got you down.
All right, thank you.
On Skype now?
Yes.
All right, next caller. You're unmuted. 831.
Hi, Christy. It's Dennis from California.
Hey.
Hi. Yeah, how would I go about getting, hooked up with, under an ambassador that I could work with?
Make an announcement on all the Monday, Tuesday, Wednesday, and Saturday calls, looking for a trust ambassador.
Okay.
Type handles so you can get into the NTT group and just kind of push it out there.
It's like, tell you what my Skype handle is right now, and anybody that is in California that's close by could Skype me.
Sure, go ahead.
New York 11.
New York 11?
New York. D-Y-O-R-K 11.
Okay, is that, could you spell that out?
D-Y-O-R-K 11.
One more time.
D-Y-O-R-K.
So that's D as in dog, Y-O-R-K?
Yes, 11. 11.
New York. Okay.
Yeah, New York 11. Yeah. I have a gentleman that's been helping me with a lot of the documents, but as I've been reading and listening, questions come up for me that I just need, he's busy doing his thing and doesn't have time to answer all my questions, which, is understandable. So I'm just looking for someone that I can work with that can clear up some of the confusion that I would have, or at least get some clarity on some things that I'm not quite sure about.
Yeah, well, you get an invitation into the Welcome NTT group, and you can ask your questions there. So.
Okay. Yeah, I'm on that. I just didn't know. I'd like to be able to maybe work with somebody one by one, one-on-one, if that would be possible. Because just because there's, rather than putting all this stuff, there's some personal things that would probably be easier if I was just working with one person.
Situations and don't give out the pertinent details.
What's that?
Use hypothetical situations and don't give out the pertinent details.
Okay, all right. I'll think about that and put it in that context then. Because I don't want to go on debtor creditor side, and that's a lot of the stuff that I would be talking about. And since I've been learning about NTT, to move away from that, like IRS frivolous letters and stuff that I'm getting, I don't think would be appropriate on these calls. So that's why I thought if I was working with someone one-on-one, it would be better.
Yeah, we're trying to keep the NTT stuff pure, but how do we go about teaching the discernment? What is like debtor creditor, and what is?
I'm pretty sure I know what that is. I'm pretty sure I know what that is, because I'm learning about NTT is really opening my eyes. But there's processes that I already have in place that I'm wondering if I should just go ahead and succumb to debtor creditor and go along with what they're saying in response, just to end the controversy, and then later pick it up on NTT and express it that way, like IRS frivolous filing letters, things like that.
Well, I think those stem from the fact that you haven't withdrawn the general deposits and you're still classified under being debtor creditor by default. And once you change the general status, general deposit to special, I think that's going to, like a light switch, turn it the other direction.
Okay. So to understand that and get clarity on it, and to go into more detail on it, that's what I would like to do.
All right.
That's
So
what I thought it might be
doing. Status for, say, being defendant, which is nothing more than by default being the general deposit.
Yes.
And being under debtor creditor is we change the nature of the deposit by withdrawing it from the general and redepositing it as special in the private. And what we've done by that is we've really merged titles.
Gotcha. Yeah. So then what I would want to know is how to actually do that within the process that I already have started, or if there would be another option.
There's one audio, I'm not sure what the date is, but it's probably been at least 2, maybe 3 months ago, where we talked about the nature of the deposits, and we were talking about general versus special. And on that day, 2 or 3 audios in a row there. We talked about withdrawal, we talked about redepositing, and we were talking about general versus special.
And I think I've seen that one too. Okay, I'll go re-listen to that one.
There's about 3 of them, like right in a row. Like it was started on like Saturday, and it went to Monday and Tuesday, or something like that. But there's, and then I think we might have jumped to another topic then.
Yeah, let's see if I remember exactly.
You have to terminate the guardian-ward relationship also.
Right, and one of the MP3s I was listening to started to go into, I'm not sure if I was understanding it correctly or not, about doing the NTT technology on our birth certificates and doing the taking it out of general and putting it in a special deposit with that trust. Did I misunderstand that, or was I hearing that correctly?
I wasn't following. Could you explain it again?
Well, so I think when I first started listening to MP3s, it was some people. It seemed like I was hearing that, you know, in order for, you know, like a lot of us claim our UCC, you know, birth certificates on UCC, except for values, send it in to the Secretary of Treasury or Secretary of State, and you know, to use for set-offs.
Yeah.
And I thought I was understanding what I was hearing is how to do that using NTT.
Okay, we're using NTT in two ways. We're doing it on a master plan, which is we're terminating the straw man trust account and all, well, you know, everything that goes along with it, all the sub-trusts and everything associated with it, all in one fell swoop. Or you can use NTT on an individual case-by-case, count-by-count basis.
Right. All right, so then I didn't misunderstand what I was... Okay. That cleared that up for me. That makes clarity for me. Now, the other one was the MP3s that start out the nature of deposits. Is that the one on 5.8?
That sounds like it might have been the one, yes.
Okay. All right. And then it has, underneath that, it has the withdrawal and redeposits on 5.10.
Before that, maybe, or after that, and see whether or not you got... But there's about three of them all in a row, 3 or 4 of them in a row.
I'll find them. Thanks, Christian. And tonight was really great. I love listening to Marshall and Chris. Of course, he always, you know, pushes my brain to the limit when he starts talking. So it's always I feel good being just, you know, on the call and listening to everyone. This is and this all feels really good. It all feels right. So I'm really anxious to learn all I can and teach other people too.
Okay. All right. Well, we're vendors here.
Well, thank you so much.
Okay. Next caller. Jeff, you're on.
Hello, can you hear me?
Yeah.
Christian? Hello. Good evening.
Yeah.
Okay. So, yeah, really great call tonight. So just to kind of review the pleading. So we're basically doing special pleading. For your first pleading, you put into court is basically a caption that says public... Excuse me? All right, hold on 1 second. Sorry about that. Forgive me. Okay. Is that better?
Yes.
Can you hear me?
Yes, go ahead.
Okay. So basically to get into the equity is, like, for example, injunction, is that automatically in equity?
That's an equitable relief, but that doesn't get you into equity.
Right. So your pleadings, basically special pleadings, but the first pleading you turn in is a public pleading, you said, like with a caption set, like any other regular motion type pleading.
Yeah, it looks like the regular thing, except it's got the pleading special matters, suit and equity, it's got that equitable maxim, no adequate remedy in law.
So you put that all in your pleading. That's basically your pleading is basically a special pleading special matters pleading. That's all really. Is that what you label it?
Yeah, pleading special matters. It goes in there.
Okay, so that's, you just make a caption say pleading special matters, and then refer to your maxims as law.
These are like switches. This is suit and equity. That's a switch. This is pleading special matters. That's a switch. This is a counterclaim. That's a switch. And this is a breach of trust. That would be the cause of action, but that's a switch also.
Huh. Wow. So yeah, you just file that, and that's boom, instantly equities in play, basically invoked. I'm filing that when pleading.
Yeah, if you don't give too much away, yeah, so that's a trick. You know, put enough in there, but not everything.
And then obviously, then from there, you just want to get into chambers and issuing a letter rogatory from the private to the public so the public can see it, the judge, essentially, is your basically your next step, sort of. But then, where's the NOI fit in exactly then, the NOI and SOI?
NOI is the pleading.
It is? Oh, okay, so that's just your notice of information as you're pleading, basically. You're pleading special matters.
Your SOI attached to your public NOI would be your notices, your UCCs.
Okay. But those do you attach them as exhibits, or do you actually give them SOI? Do you make a pleading for that as well.
Those are evidence. That's exhibits, yeah.
Exhibits, that's it. So, interesting. Very interesting. It seems so elusive, but simple. Bizarre. Yes, it just... So, from then on, though, you don't have caption sets on your pleadings. So your pleadings are basically just letters. If you do have any other issues that need to be addressed.
On the private side, right.
Yeah, so they're just... So would a conditional acceptance be part of that? I mean, could you do it in the form of that? Like just to extinguish controversy? Or is the facts are irrelevant at that point?
This is more along of commingling.
Commingling back to creditor-debtor?
Yep.
So you just got to stay with strictly the trust terms and be in the trust position, always be the grantor.
I think that was on call a couple nights ago, and he was telling us about his court appearance that he made in there, and he was saying, you know, he was the grantor, and he was getting the judge to accept his grant of his name. And he was trying to get the judge to accept it, you know, like conditionally, really. You know, he was trying to get him in.
Right.
He didn't have to do that. All he had to do was grant his name.
So when they ask for your name, you say, "Oh, I'll grant you my name."
Yes.
Oh. So they go, "Okay, what does your name say on the birth certificate, for example?" If the judge asks you that question.
Yes, I grant my name for a specific purpose.
Just qualifying it.
I'm going to say that specific purpose that I want.
Is that basically the same as special appearance?
Yeah, because you're doing everything specially, yeah.
All right, so...
appearance any longer in certain cases. But
well, they won't... Yeah, so they won't take special appearance. You're saying if you say I'm appearing specially as for example, the paramount security interest holder, that's kind of commingling again.
That's commingling, yeah. That's debtor creditor.
So you just basically, I grant my name for the specific purpose of...
Yeah, I'm here as the grantor, in fact.
Yeah.
And I should have put all my paperwork in prior to me being there. And when I stand there before the judge, granting him my name, only an identification for the purpose of finding out whether or not everything has been extinguished. That's the only reason why.
That's great. So that's your special purpose of giving your name.
I'm going to correct any matters that have been misconstrued or mistaken.
Yeah. Correct any matters.
Yes, the first thing I'd be asking out of my mouth would be, you know, has the debt been extinguished?
Yeah. Now, do you tender any kind of payment?
Yes, absolutely. Equitable assets as a merger.
Not the UCC1 and UCC3.
No, those are only instruments pointed to for them.
Yeah, so what are those instruments then? What are the instruments that would be tendering payment?
Well, what actually makes the payment?
Signature.
Okay. What did you do with the signature?
Well, I put it on the pleadings, and if I was in debtor creditor world, I would have put it on their instrument.
No, you lose.
I know. That's why I was just saying that because I figured I might as well say the wrong answer.
Sorry. What does the nature and character of the signature get changed into with time?
Money. Or
like you ran like 6 steps too far ahead. No, let's just take this one step at a time.
Okay.
There's something in between you're missing.
The signature will have to be qualified, but...
All right, how are you qualifying the signature?
Usually as AR, as grantor.
Yeah, well, no authorized representative. As grantor, yes. I think authorized representative is more for debtor creditor stuff.
But couldn't you be authorized representative of the trust, and depending on which position you...
Qualified your signature as grantor, now you're getting a little farther. I mean, you may be one more step ahead, but now what's the next step? What is it? Because everything's going to change within time to from one name to another name. As it moves along the timeline, its name changes as it progresses in time, although it's the same thing.
I got it. So you go from grantor to beneficiary.
Yeah, okay. Yeah, right. Eventually. But that's too far ahead.
Okay.
What is it that makes the payment that you signed with your qualified signature?
The bill.
Yeah, but that's the title to the debt. You're still needing something else.
This is the missing piece. Let's see here. Okay.
Antithesis of the title to the debt.
The asset.
Yeah, but a particular kind of...
Equitable asset. The asset, the private side asset.
Asset. All right, now we're getting closer. What do you call that equitable asset that makes the payment?
A signature.
No, you went back too far again.
Oh, no.
Everything we do is special.
Special. Okay, so private equitable asset that makes the payment.
Yeah, but it's special.
Special.
The special what?
Special pleading. Special notice.
You're off. You're getting too far off. You're getting colder.
Oh no.
Yeah, but you're getting colder.
So special deposit, of course.
So we change the nature from general to special.
Right. When do we change?
And what do we do after that?
Can you repeat it? I'm sorry, I missed you.
We do a withdrawal, and then what do we do after that?
Special deposit.
Special deposit.
Yeah. Okay, yes.
So your special deposit title is your equitable asset that you combine with the debt title, and when you put the two together and return it to them as merged, now that extinguishes the debt. That made the payment.
Okay.
Now, what is your evidence that you did that? Now we're back to the question, the point where we're trying to get to. Where is the SOI that proves that? Because it's not the UCC 1s and 3s. It's not the counties. Those are only notices of a past deposit. Where is the record of the actual deposit? Let me ask you this. When does the trust form?
Trust forms when there's notice, when it's expressed.
No. Trust forms when actual trust res was put in the hands by delivery to the trustee.
Oh, okay, yeah.
Now, how do you prove that?
Would that be with the UCCs?
No.
Let's see.
UCCs are just notices. They are not the evidence. They point to the evidence. They're just public notices, the UCCs and the county notices.
Right.
Point to something in the private that is the actual facts to substantiate an actual transfer by delivery of trust res. What would that possibly be? How would you send trust res, which would say be special deposit paperwork, to the trustee?
Privately.
Okay, so you'd walk up there and just hand it to him?
I have a notary presentment.
All right. And how was the notary presentment made?
Registered mail.
Okay. And what do you get when you get registered mail?
A receipt.
A receipt. You get a green card?
And a white card, yeah, a signature card and a private mail slip.
So that is your actual private evidence that you delivered to the trustee. He signed for it, and he's got it.
Okay.
Now, remember, you need two witnesses to substantiate any claim. So if you claim you sent trust res, you got to have two witnesses.
That's where the Secretary of State and potentially the county recorder come in.
No. Those are only notices.
Okay.
That's not actual evidence.
So
Those
the
things
witnesses...
do actual evidence.
Yeah.
Those county reporters and those UCCs are only public notices so that the public has been notified so they can see something, but they don't see clearly what it is because they don't have the facts. The facts are held in the private.
Right.
The facts are the green card, the notary sworn statement that he did a presentment, and your affidavit testimony. You're one witness, and the green cards and the notary are other ones.
The green card and my affidavit and the registered mail slip.
Yeah, and the notary would be three witnesses. So that notary made out a certification of mail delivery, and he specified that he put such and such and such and such into an envelope and mailed it to him on a certain date by a certain method.
Right.
And he did that under his hand and seal. Mm-hmm. You got the green cards and the receipt, and you got an affidavit swearing to it with a proper foundation laid and the testimony to swear to those facts. Mm-hmm. Now you got evidence. You got SOIs. Mm-hmm. You got private SOIs to substantiate your private NOI claims, your letterogatories. And then simultaneously, you've got on the public side, you've got public NOIs, you've got a cause of action, pleading, substantiated by your UCC and county recorders, SOI, public SOIs attached. And now you got control of both sides of the case, both sides of the court.
Oh, man. That's pretty amazing. Get it. Got me. Mastermind. Basically masterminding both sides. Let's see what you're doing. So, okay. The letterogatory is on the private side then. That's basically the pleading or the confirmation of the public seeing the private pleading.
It's an instruction.
Instruction. Essentially an indenture?
I didn't hear you. What?
So it's not, would you consider that the indenture?
A part of it, yeah. Indenture is instruction of the will and purpose of the grantor.
Right, so the letterogatory is essentially the indenture.
Yeah, so I might want to put in a letter explaining the indenture and then put the indenture, say, with it.
With the letterogatory, got it. Goes right with it.
And then give some kind of instructions what I'm trying to accomplish here on the private side. Take this evidence, give me a ruling.
That's when you want your evidential hearing.
Yeah, yeah. But now you have to have a public side motion on the public side to set a hearing, call a motion for a hearing. You got to move the private side, move the public side to set it up.
For ratification, set off settlement closure.
There is no settlement closure. It's extinguishment and discharge.
Yes. And would you use those kind of terms in the public?
Yeah, because you're using the debtor-creditor language, and we need to get that vocabulary out of our trust mind.
So, yeah, extinguishment, and disbursement? Discharge. What about the disbursement? Is that just strictly done in private if you want disbursement?
Well, disbursement would be from termination of the trust or making a payment out of the trust, yeah.
I mean, getting paid, essentially if you're in a case and you want to get paid back, say you've been injured and damaged, you want to get your disbursement. Is that, I mean, that's the way I see it, I guess. Maybe that's still coming from creditor-debtor, but essentially if you had, an equitable business that's been destroyed, let's say, and you want to get compensated, and there's no remedy at law, so you have to go into equity.
Yeah.
Does that make sense?
Yeah.
So you request or you demand your disbursement as well at the point of the extinguishment and discharge.
Yeah, but after I've claimed and proved and executed a trust.
Yes. Executed is basically doing that in person in the courtroom or in the private, essentially. Going
from the moment I brought it into its inception.
Yeah. Paperwork, but then what Marshall was requesting, it was actual court inside the courtroom dealing. Because that's really, you can have all the proper paperwork without being able to properly conduct yourself or to, I don't know how you would express the trust, essentially, in the courtroom.
They can't see it, even though you're sitting there hanging on with the evidence.
What's that? What was that?
It has to be in the form that they can see, or else even though you've got it in your hands, they can't see it. It's got to be in the form that they can see it.
And that's where the public pleading comes in. That's where the letterogatory comes in.
Yeah.
Those are the forms they can see going from the public, basically bringing equity into the public. Then you abandon it once you get into the private and use the notary presentments. Still pleading special matters.
Right.
Yes. Okay. That was pretty groundbreaking. Thank you so much. I really appreciate it.
Anything else?
Well, for the cases I've been that I have some experience with, I've basically I've done my UCC 1 And I at that point was pointing someone like a assignment to a treasury person. Now, do I have to go back and redo that potentially? Because I was essentially appointing a treasury person as a fiduciary trustee in some sort of, I was expressing or assigning to him.
Treasury person was trustee?
Yes.
No, I don't have enough information there. How did he become trustee?
Well, okay, by the assignment of the res.
The assignment of the res.
Yeah.
On what?
On a notice. But I guess it's, and also UCC1 and also sending a presentment, notary presentment to him.
He does not become trustee upon assignment on a UCC3.
No. What about a notary presentment, an actual mailing to him?
Remember when the trust, I said the trust was formed, when the trust formed?
When the actual res is put in the hands of the trustee, so the green card, when he actually got and signed it, or one of his agents.
And when he actually got trust res, that's when the trust was formed. That's what made him trustee.
Right. So the registered mail and the signature card.
You got to have, when we're doing this, you got to have the basics down. The basic comes back down to the elements necessary to prove a trust. And what are those elements?
Well, basically that there's let's see, the res, the parties, and the intent, and forget what the other step was.
Been pretty good. Purpose.
Purpose, yes, purpose. I was going to say probability.
Specific res.
Yes.
Four elements.
Yes. So the purpose, could the intent be for remedy and the purpose is to protect the res?
The purpose could be for any lawful means.
Yeah. So that's justified, protecting the res, and the intent is for making all parties whole or bringing the remedy.
Yeah, you can make the trust anything you really want as long as it's, according to law.
Yes. Okay, so basically, yes, the four purposes.
One more thing. You got elements. You got 4 elements.
Okay.
Which are really 6. Because parties breaks down into 3 parties.
Right, of course.
So now you need one more thing.
Let's see. The res, parties, purpose, intent, and...
You need a method of formation.
Method of formation. Which is, once again, goes back to the green cards, I would assume. Mailing your notary presentments.
Delivery is one of them, yeah.
Okay.
Now, if you've got all 4 elements, and one of the methods of formation, you've got a trust. You've got everything there that the law must recognize as a trust. There's no way. Everybody's going to stumble because the judge didn't recognize their trust because he couldn't see a trust because you didn't have the elements and the methods and everything necessary to prove the trust. If you prove the trust correctly and you make a prima facie case for the trustee's breach, you're in equity. If you don't get into equity, it's probably because you did some little stupid thing wrong.
Yeah. So that's essentially putting that pleading, putting in the pleading, basically, the special pleading, the notice of private equitable, basically going from the public to the private. And then also...
enough so that you don't put the truth or the private facts, which needs to be protected. That you don't get into the public side because you're breaching your own trust by commingling it. Commingling, taking your private evidence from the private side, and you're shoving it into the public court, and you're breaching your own trust.
Yeah.
And they know that.
Very interesting.
They will try to get you to probably do that.
Of course.
If you do that, you lose.
So essentially, that caption says so simple and very little on it. You don't really want to give your information. Then you actually make your bill, your private bill, special pleadings after that. After you turn in your caption set, then you turn in your counterclaim after that. And I would assume your counterclaim, you don't have a caption set on there.
In the private side?
Definitely not. Right.
No, you don't need a court heading on that, I don't think. You just need
yeah, because that would be bringing it into the public. You'd be traversing into the public by doing that.
You don't want to bring the private stuff or the public stuff into the private.
Right, obviously. So the counterclaim is really essentially just a written form of a claim without the caption set.
Yeah, you keep the form, process, and procedure on the public side. You keep the substantive rights on the private side. And the twain don't mix, like oil and water. If they do, got problems.
Yeah, you lost it.
Yeah. You breach the trust, you commingled, and you become incompetent, and you lose everything.
Aye. It's a very fine line there, just to really pay attention. But it is like
it's either black or white. It's very simple.
Yeah, but it is very easy to switch from equity to back at law, especially when you're in the public. I mean, it's very difficult to get into equity. You can't really be
under one-track mind, and our one-track mind doesn't go anywhere except where our one-track mind leads us, which is right down debtor-creditor alley.
Yeah. It's really just staying private and getting into equity and just sticking in equity and knowing how to stay in equity with your presentments, essentially. And then, what if the judge doesn't want to grant you a in-chambers hearing? Or the evidential hearing? He has to. Is he bound to?
He doesn't grant you an in-chamber hearing is because you don't have evidence there that needs to be protected. You haven't showed him evidence that needs to be protected.
So that's where the CI comes in.
Yeah, the protective order.
I guess really at this point, what I would like to review is just basically kind of an order of operations. So your first order of operation is a caption set, public pleading, basically bringing you into equity.
And just like a special.
What's that?
Just like a standard pleading. Right.
Yeah, basically caption set, public pleading, special pleadings, basically. That's all you're really pleading.
Counterclaim, which the plaintiff to the defendant and switches defendant to plaintiff.
Now, do you set your caption set up like that?
Yes. Third-party counterclaim.
Third-party counterclaim. Okay. And then from there, you actually turn in your actual points of interest in your counterclaim, your causes of action.
Right, cause of action. Yeah.
Okay, and then from there, that's also accompanied with an affidavit. Right? And your SOI.
Make a prima facie case for the breach of trust, say, or the payment has been made. If the payment has been made, it's because of the breach of the trustee then.
So close. Weird. Just because debtor-creditor stuff is so close to this. It's so similar. It just seems like they could be converted. I guess that's where the commingling keeps coming in. Very similar concept, but sticking with the trust.
That's the same stuff, but it can be interpreted as being one or the other. It just depends on how you express it.
Yeah, so it's really the special deposit. You now have general. And everything special is basically private.
Yes.
So just public pleading, special pleading, third party on the caption set, basically. Your counterclaim, which I'm assuming your counterclaim comes maybe a day later, 2 days later. Private counterclaim.
File the filing fee with the counterclaim, issue the summons, subpoena in the trustee.
You name the trustee?
Yeah, you've got to.
Yeah. And also the beneficiary. You have to make known who the beneficiary is, right, which is yourself.
Don't have to.
Don't have to. Just have to name the trustee. I guess, is it...
I get back. This is a court proceeding, so there's no trustee representing the beneficiary, so it would have to be the beneficiary. Beneficiary.
So what's that?
Beneficiary would have to be bringing the action, because there's no trustee representing him, because the trustee breached, so.
Right. The beneficiary would have to bring it. Okay. Yeah. So you name the beneficiary. You have to name the beneficiary then.
I would say I'm grantor beneficiary.
Yeah.
It's beneficiary.
Yeah, that's kind of what I thought. Okay. So no more authorized representative anything. You're a grantor beneficiary all the time. Isn't authorized representative kind of a portal term, though?
It can be used as, but you have to have a private contract with the trustee or, say, the grantor, that he would be doing some kind of duty for the trustee. If you don't have that, you can't use authorized representative.
Oh. You have to have a private contract with the trustee or the grantor, you just said.
Yes.
So can you have a private contract between yourself, the grantor, and the beneficiary?
As long as you got a contract between,
for example, the straw man and the natural man?
now you have to think about, commingling, breaching sides, because the one can't be seen in the other realm. So you can't be making contracts for a private side entity on a public side contract. You got to be doing the public side contract with a public side entity.
Got it. But okay, so public side contract with two public entities, then essentially.
Or you're going to have a private contract between private entities.
Okay.
If I got a side contract with a private entity, then I won't want to bring that in the public side because I'd be commingling that. That would have to be an unchanged thing to find out that was authorized rep. So what good does authorized rep signing in the public do then? So I can't have a private contract with a private entity. It's got to be a public contract with a public entity so I can use the public side accounts authorized rep to be showing up on the public side.
I see. It's basically a moot qualification in the public side.
How's it going to show up on the public side, a private contract? If it does, it gets waived. They're going to treat it as a public entity. Then you just commingle and breach trust again.
Oh, gosh. Always grantor and beneficiary. Okay. That makes sense. Really, you never get to the point of where you're the authorized representative because you're really probably not going to go through having a private contract with another private individual in the courtroom.
Well, I could. Yeah, that would be an extra layer of protection.
That'd be nice, but how are you going to get the meeting of the minds to do that? That's challenging. Because mostly it seems like we're...
I would keep it simple, yeah.
Yeah. Because basically right now we're getting it by acquiescence, essentially.
Let's get to the point where we can claim and prove trust.
Yeah, all right. That makes sense. Sorry about going. I guess it's like, just stay focused. Keep it really simple. Don't try and take too many steps ahead. Just prove the trust. The fact of the trust.
Get your advice first, and then you can go from the 26-inch one to the 30-inch one.
Okay, my last question then is the YBNs and all that, the IRS stuff. Is that the same with that? Do you keep that for later on? That's like further on down the road, would you say?
What was that?
The IRS forms, the YBN, and all the other IRS forms. Also, is that like further on down the road?
I could use those, but then I don't really need them in this particular case, I don't think.
Would they be SOIs also?
Because that W8 IMY, that's going to be that W8 bends and that would be used for if somebody wants me to certify that I'm not a United States citizen, I'm a private entity. That's the thing I would give them to prove that. Yeah. As long as records matched in my IMF safe, then that would substantiate. There would be no conflict.
Yeah. But how are you submitting that to the IMF?
To the IMF, that'd be the IRS IMF. First of all, if you read the form, it says, do not send the W8 bin to the IRS.
Oh, so it's the IMF. Okay. Well, a lot of issues, a lot of points, and made tons of notes here.
Okay.
Thank you for the call. Thank you for all the work. God bless.
All right.
Bye-bye.
Next caller, you're unmuted. Next caller, you're unmuted.
Hello?
Hello.
Am I still on the call?
Yeah, you're still on.
Honey, I'm sorry. I tried to cut myself off. We'll try it again.
Star 5.
Hello, Christian?
Yes. Floyd, hi.
Yeah, Floyd again. Chris brought up a couple of points I wanted to
comment on and see if I can clear something up in my own mind. Okay.
All right.
Now he did make a point about in public-private, and he said something about truck drivers. Now, a truck driver would be in the public. He would be operating commercially. So what he was talking about would be if there's a public and a private side in the public, that's where somebody operating commercially would want to take advantage of, wouldn't they?
Yeah, I would say that's.
Yeah. Well, now, and then he said that HUD has a private and a public side, and that would be commercial. Now, if I was dealing with HUD as a private man, wouldn't I just take the HUD material or whatever it is that I was dealing with HUD in and just put that in as trust res?
Yes, well, it's like, this private side of these corporations is like the
turn off the lights.
Like the private side of the courts.
Yeah.
But it's hidden. It's just the same way getting into these private side of these administrative sides of these corporations, these government entities. Otherwise, you're going to be what you think is in the private, but you're not. You're accessing what you think is the private, but you're on that statutory equity side instead of the private equity side.
Right.
Well, that's why I keep stressing with Chris. You got to watch out for that, because not everything that you say is private is private. It's still public.
Yeah.
You got to watch that, because it has to be private, so to speak, or special private, because there's this double door like that. If you don't watch out, you think you're in a private, but you're not.
Well, for example, if I'm operating my vehicle myself, I'm operating my vehicle privately. But if I'm operating as a taxi driver, then I'm operating publicly.
Right, and there's probably no private available to you. You can get
as a taxi driver. That's true. Yeah.
You probably get private side corporate because you're operating commercially.
Exactly. And that's where I think that's
thinking that you were in the private side. That's really a good point you brought up, because that's the point I've been trying to make all along.
Well, yeah. See, this is where I think herein lies the confusion of what is being said most of the time. We're always thinking commercially instead of privately.
Yes. We have this debtor-creditor mindset ingrained in our minds 24/7 practically.
Yeah. So anyway,
we don't duality. We don't think in duality. We don't think in private-public realm.
Right. Okay. Well, I wanted to make that distinction because that is confusing to people who haven't had a lot of experience in this trust material.
Yes, and that's what I've been hollering about on a private group, to make sure that we keep NTT pure by keeping out the debtor-creditor crap.
Right.
By teaching people the difference and thinking in a duality and getting the basic concept of public versus private down.
Yeah. Well, this last caller, the things that he was bringing out were exactly what we need to understand, because he's pretty well got it nailed down.
Yeah, there's some fine points that need to be specifically addressed there, but we're getting closer and closer. It's like top is the main model, and as you come down, it gets wider, and you get more detailed. And finally, at the base, you've got all these individual details, but by then, you've got the picture.
Yeah. Well, I see in my court case, I didn't do some things right. I didn't put in a letter. Well, I don't think I need to put in a letter of rogatory until unless the judge comes back and doesn't give me my my remedy.
Yeah.
Then
Well,
I have to.
if you take into consideration what we read today in about the trust, it's that it should not be misconstrued to lead to the defeat of the trust. So even if there are points missing, say, it is supposed to be construed and filled in those points so that the will of the grantor is completed for the benefit of the beneficiary.
Okay. Well, I turned in all of my material. I turned in my indenture, my SOI, NOI, trust res. I gave them the instructions to the trust. The only thing I didn't do is I might not have entered into the public side correctly. That's the only part that I wasn't quite sure after listening to what Marshall was saying. I might have. Pardon?
You had, right?
I'm sorry, I missed that.
You had a ticket, right?
Yeah, right. I made reference to the traffic ticket, and I gave them instructions how to handle it. That's basically what I did.
Oh, we'll see what happens.
Yeah, right. And if he doesn't give me my remedy, I think I'm going to use him for a DIB hearing.
Remedies on the public side, it's relief on inequity on the private side.
Okay, well, I can talk to you about that a little later then. We'll see after the, let's see, we'll know on the 13th what happened. Okay, very good. Okay, I just wanted to kind of talk to you about that a little bit. I wanted to clear that up in my own mind. Okay. That's all I have for now.
Okay, Floyd, thanks.
Thank you.
That's it. All right, Chris, one more?
You did.
Yeah, one last thing I wanted to share with you. Working with Michael Anthony. You remember Michael Anthony, don't you?
I think so, yep.
Yeah. He's generated some papers which are a declaration of the Ninth Amendment, and it's interesting. And I wanted to just share with you that particular amendment says that what has not been expressed as a privilege by the government is reserved for the people. And apparently, with his research, he went in there and discovered that you can do a declaration of the Ninth Amendment which secures your unalienable rights, of which he painstakingly went in there and detailed the claim under a declaration, and he's perfected that document. And I haven't had much of a chance to look at it, but I wanted to share it with you that what it does do is it exempts you completely out of the commercial realm. And it's beautiful. It's absolutely just beautiful. And even if it was just a minor step or a stage that a person can take in order to get to where we're moving towards, that would give some relief to our followers or comrades or people across the United States. This document is killer. Once you serve it upon your county and your state, it completely exempts you from all statutes, codes, and regulations under the Ninth Amendment.
And what do I do then?
Pardon?
And then what do I do then? Like live on an island in the middle of the Pacific?
Well, I don't know. I would sure like to.
like what was that? What was the name of that movie?
With Tom Hanks?
Yeah, Hanks was there.
Yeah, where he was lost on the island for...
What was the name of his buddy?
The little coconut.
Yeah.
I don't remember. But anyway.
Right. If you expatriate out of straw man and you eliminate, and you're not in commerce anymore, where are you? You're on an island. Just like in the movie in The Matrix, when he said, this is it. This is what the reality for today.
Well, it may not be for you, but it is for a lot of people, and I think it's a good remedy, and I'm just mentioning it only for the fact that I'm going to have him as a guest speaker over on Tim Turner's call this next Wednesday.
It's like, where do you get your colorable titles? Did you gain access to the real things that you're so accustomed to using and needing on a day-to-day basis? And you have to go through that colorable realm, that commerce realm, to get those colorable titles. I like my cell phones and my computers and my Publix meals and everything, Boston Market and all this stuff. I like that. But if I'm not in commerce any longer, that stuff is not available to me.
Well, I don't... you know Bill Thornton, right?
Yeah, I know him, yeah.
Okay. He lives quite comfortably being able to exercise his abilities to interface with commerce anytime he wishes, and therefore he retires out of it at his discretion. And I don't think that this is too far off from that set of principles of being able to exercise the ability to stay sovereign unless it is deemed by you, your decision, to enter into commerce, of which once you take care of your business, you take care of your business, and then you retire out of that back into your sovereignship. I don't think that you're expatriating with what...
Isn't that commingling and breaching the trust?
Pardon?
Isn't that commingling and breaching the trust?
Well, it depends on which trust you're talking about, because...
Go into commerce and go back into commerce again, then isn't that commingling? Something that I've gotten out of, but yet I go back into it? If we start thinking about this stuff, it doesn't make sense. I want to get out of commerce and get out of commerce for good. I don't want to go back in there.
But that would be like living on an island, and I'm trying to find a medium between the two.
Hey, how do we get out of commerce, but yet not live on the island?
That's right. I'm looking for that same medium.
Yeah, that's what I'm trying to point out. And we can do that. NTT Trust has got the solution for that. Because we interface back in, not as ourselves. We're not in commerce. We're going to interface back in as another entity that isn't even us.
Well, actually, to tell you the truth, maybe you're responding in a manner that doesn't really address the Ninth Amendment, claiming the unalienable rights. That's not necessarily to say that you're expatriating, and it's not necessarily to say that you can't be at a happy medium with interfacing with commerce.
There is no happy medium. It's either black or white, or else you're commingling.
Well, what you're saying is stay in commerce and work trust to where you can be at the happy medium. Is that what you're trying to say to everybody?
Yeah, we're like going around, we're achieving what we want by going around the opposite direction.
But still functioning from commerce.
Yeah, we're not functioning from commerce like we were before. We're functioning from the private, and we're not going back into commerce. Before we left commerce, we set up an entity in commerce that when we leave, we're never coming back, but we're going to operate through that as a consumer. We're going to use this entity to purchase the consumables that I need on a daily basis. That way I'm never lack for one. And we're going to get another entity to create the transactions or the trades to generate the interest to put into that account on the public side that will look just like everything else in commerce, and nobody's the wiser. And I get to buy the things that I need, whatever I want, and I don't need to generate a profit or an income or do business, and I'm not effectively connected to a business or trade in the United States, and therefore I'm out operating solely in the private, but yet I have a jig-jag interface in. I think all these other guys are commingling and breaching and don't really realize it because they're doing nothing more than the debtor-creditor's realm with a different face mask on, thinking they're achieving the same thing and they're not.
Well, I don't think
Trust has a totally opposite view of all these other people. There is nobody thinking this way.
Well, I don't think it's too far off from what we're trying to accomplish here. We're claiming...
Parallel paths do not come to the same point.
Say it again?
Parallel paths do not come to the same point.
Yeah, I heard that one before.
They may look similar, but they're not. There's a difference. They're parallel, separate. They seem to be going along the same path line, but they never meet. They never join up as a point down the way. So therefore, they are different. That's debtor-creditor versus NTT. But you've got to get the training down in your mind to recognize the difference, because they are so close, you can't tell the difference.
Yeah, that's the truth.
The debtor-creditor thing in Gilbert's, when it talked about the different types of relations, it said in here, let me pull it up. It talks about under section C, trust distinguished from similar relationships. It talks about number 1, characteristics, not terminologies controlling, section 27. It says similar arrays of rights and responsibilities, including fiduciary duties and obligations, may be found in a variety of other relations that are, in varying degrees, somewhat similar to trust, but which lack one or more essential characteristics of a trust. It is often difficult to ascertain whether the parties involved intended to create a relationship that is recognized in the law as a trust, because the use or the failure to use trust terminology is not conclusive of the parties' intent. They're saying there are relationships out there that look very similar, but they're missing one of the elements, and they are not the same, even though they look like it.
But are you saying that unalienable rights and putting a claim to those is under the debtor-creditor statutes?
I don't think you can claim your unalienable rights by Constitution. Constitution doesn't give me unalienable rights. God gave them to me, not man. There's benefits.
Well, that's part of why I would describe that as being a trust. That's a natural trust with God. That's your relationship with God.
Yes.
So I don't think that I'm too far off from maybe it's just different language.
Oh, no, it's. I think you're looking at stuff that looks very similar, but you're not able to quite tell exactly whether or not it's pure NTT.
Well, I've heard enough people talk about God and their relationship to God, which is a trust, and I agree with that. I think that every man ought to really review or audit himself to find out what his priorities in his lifetime. One of them is God. My relationship with God is my trust. That's how I conduct all my activities in my life. And so an unalienable right and putting a claim to that is within that trust. That's my primary trust.
Yeah, I won't disagree with that.
No, you shouldn't, because it's right up your ballpark.
Yeah.
And, I believe in God, and I believe that my work here on this planet and this body is right up the same vein you are doing. And that's why we get along with this stuff, is because I believe that is your primary trust, too. So I don't see that claiming an unalienable right is acting under debtor-creditor. But, maybe you've got a point. Maybe I'm not understanding your point about claiming an unalienable right as being a debtor-creditor status or statute.
Well, what I'm questioning is how it went about claiming it. That's what I'm questioning.
Well, yeah, that's a different story. I mean, if you do it, it's like anything else. If you do it correctly, and that's what we're trying to learn here, is every time that you open your mouth, it ought to be exactly with the wording that expresses the intent. And no, I agree with you on that. And we're trying very, very hard. We're trying to get the language right in order to express the intent of where we're at and what we would like to have as our status.
Yeah, if we keep on, you and I will probably meet somewhere in the middle eventually.
Yeah, and that's cool. It's good for diversity, because it gives the other person's the ability to reflect on things that were said that didn't all come from one source.
Right.
And like I said earlier, I have absolutely no bones in my body to be adversarial. Everything I try to do is to compliment each and every person I engage with to see what we can create, and the beauty about it is that if you work on it and you've got good relations, divinity actually can occur.
Chris?
Yeah.
This is Michael. Remember, the Constitution is for them, it's not for us.
Yeah, but the unalienable rights are naturally given by God, and that's what I'm talking about. I'm not talking about the Constitution. You are.
Well, I realize that. I know that the Declaration of Independence is for everyone, but the thing is, some of the stuff that you're leaning on is through the Constitution, and I'm just saying be careful, as CW is saying. That's all.
Mm-hmm. Yep. I am one of those few people that will look at everything, and then I come to my own discretionary understanding and decisions about the development that I'd like to entertain. And so if it includes the intent of the Constitution, it is a trust in itself. Maybe I'm not a party to that, but it's still something that this country is guided by, of which if I exempt that and didn't have that as one of my material facts, well, then I can't see the whole picture.
I'll agree. A country is guided by it, but which country? The democracy or the republic?
It doesn't matter. It's up to my discretion to
yes, it does matter.
Well, my value, it's like when somebody shares something with me, unless I don't have a value, it means nothing to me.
How do you do it?
I have to actually value, and one of the things that I realize about shamans is that somebody puts a curse on that shaman, and that shaman either believes in it or they don't. And depending on whether they believe in it and or they don't, is how it affects them. They know the difference between the value of something that they can't support or believe, therefore they don't support it, therefore it doesn't affect them. I don't know if you got that, but...
Well, it might not affect me, but, it may affect my brothers, and I'm concerned about my brothers.
Oh, I am too. I mean, I'm a brother's keeper, and or a good Samaritan, or whatever word, God's keeper of humanity, a shepherd, whatever you want to call me. I'm that. Whatever words you want to use. I'm a caretaker of this planet, and I'm a caretaker of humanity, and I'm there all the way for that. That supersedes everything else. This is all sandbox playtime, what we're doing, for me.
Well, anything else?
Well, anyway, I just wanted to express that I was excited. I looked at the documents, and I was excited about them. And if you wanted to review them at any time, just let me know.
Okay. Thanks, Chris.
Yeah. Have a good evening.
Carlos, you're unmuted.
Good evening. How are you?
Hey.
I had just a comment. With all my respect,
You may now ask your question.
before my mother died, in peace she may rest,
You did.
she said to be or not to be. What I'm trying to say, whether we're land trust, we're trust law, trust entity, or we're not. It does make a lot of sense. A lot of things make a lot of sense to me, but going back to the basics, to be or not to be. Because what are we doing if we commingle? We destroy the trust, right? 336. Section 336. I'm not criticizing everybody. The only reason I haven't done my bankruptcy 7, which I'm modifying to have it as a backup on my entity, because I'm not ready there yet. So I'm not no one to criticize, but when I'm ready for it, I'm just gonna drop everything and go entity 110%. It's just my opinion. Anyway, I wanted to mention something about land trust. Let's get back into trust. One thing that I hadn't mentioned in some previous calls, a long time ago, well, probably about 2 years, and I'm going to tell this to everybody who likes land trust. I have had a lot of calls, at least 20 of those, which makes me happy. I want to say something so that they don't go or they don't commit the same mistake that it cost me $9,500. When I did a land trust in all the properties, I was fine and dandy. I made a huge mistake. When I bought the following property, guess what? I commingled my name, and I used my name instead of buying it in a trust. And wham, they nailed me with a lien that they were waiting for me. What I'm trying to say, as soon as I bought something, they had a lien waiting for me. So, going back to the same basics, if I'm going to do land trust, which pertains to trust law, I better keep on it. I learned the lesson the hard way. I had to pay a lien that they had this attorney did on me, filed, he won, and had to pay. So it's an experience that I would like someone else not to go through. That's why I had to share it. But anyway, I'll sit back and enjoy it.
Thank you. Commingling hurts.
Yeah, we 336 is our biggest enemy, right?
No.
Okay. All right.
And that early on.
I'm not here to criticize anybody, Christian, to be honest with you. And I respect everybody, and I love everybody. That's why I share the little bit that I know. But we have to start with a cornerstone. We cannot start with a cornerstone and jump to the middle and then get back to the other cornerstone, and we'll never get anywhere. I want to repeat myself. I am doing creator debtor stuff. I am doing it personally. That's why I haven't gone 100% entity because I don't feel ready. Once I feel ready, I'm going to have to drop everything because I don't want to commingle. If I commingle, I'm breaching my own trust law. Is that right or no?
No, I don't suggest that anybody really does the NTT stuff until we got it down completed.
Yeah, exactly. That's exactly what I'm trying to say. But if we don't start from the basics now, if we don't start to crawl, walk, and then run, we'll never get anywhere. That's my point.
Yeah.
Anyway, Christian, nice talking to you. Thank you.
Okay, thanks, Carlos. Well, it's almost 1 o'clock. Let's call it a night. I'm tired. So. Thank you all for joining me, and we'll see you Monday. And don't forget, next Saturday is a different time change, so it starts at not 9 o'clock any longer. It starts at 10 Eastern time, 10 p.m. Eastern time. So mark that on your calendar change there. So Monday is going to be at 10, Tuesday is at 10, and Saturday is at 10. All three, the same number as this call, is at 10 p.m. Eastern time. And the Tuesday call is the only one that's a different number and a 8 p.m. call. So see you Monday. Night all.